Hello everyone. Welcome to part 2 of the online workshop for Hong Kong company law. So continuing from last time, you may recall we looked at all the different topics in the learning outcomes. We also looked at some questions from section A of the past exam papers to illustrate the different topics. And we also discussed how you might want to structure your answer. For example, if you first look at the question and you see what is the issue that is being asked by the examiner, then you will explain the relevant rules for that particular issue. You will then apply to the facts of the story, do some analysis to get your answer, and then you have a conclusion, finally answer the question. So that's what we did last time. So if you have not yet attended or watched part 1 of the online workshop, I would encourage you to watch that one first. Okay? Now we move on to part 2. So before I begin, the usual disclaimer. So this workshop main focus will be on examination technique for the purpose of sitting the Hong Kong company law paper, the Hong Kong CGI CGQB Hong Kong company law paper. Okay, so I will be using past exam questions just for illustrative purpose. Okay, it's much easier to demonstrate using past exam questions. But of course, I have not seen the exam paper. I have not been involved in any way in the preparation of the upcoming exam paper. So using these sample questions are just for illustration purpose only. It is not intended to indicate in any way what might be examined in the upcoming exam. So that's quite obvious, but I thought it would be good to have that reminder at the beginning. Okay, so the agenda for this part 2 of the online workshop. So I will be going through with you many different practice questions based on past exam. Okay, so last time in part 1, mainly focused on questions, the short questions from section A. So this time I will focus a lot more on the longer questions, the 25 marks questions in section B of the paper. So hopefully you had some time to review the topics. Better yet, if you have some time to practice answering the different questions. And then when we go through the practice question during this workshop, hopefully you find it helpful. So after going through many different practice questions, I will have some final reminders for this at the end of this workshop, and also what you can do to prepare for the next session. So let's get started. So I'll be working backwards chronologically. So starting with the most recent diet and then slowly work back to the earlier diets. Okay, so of course, the more recent ones, I think may be more topical because they just happened. And I think while it's fresh in the memory, it's good to go through them first. And then for the sake of having more examples, we will continue to work backwards to the older exam papers. Obviously, for your own revision, I don't think it's necessary for you to try to memorize past 10 years of exam papers. That's not an approach I would recommend for people attending this paper or attempting this paper because they are past exam questions. So I think quite likely you will also see newer questions in the upcoming exam paper. I'm just guessing, of course. So that's why I think as part of your preparation, make sure you also review the study materials provided to you so that you're familiar with different topics. Okay, so the way I would like to do is first look at the examiner's report. This is the general one we saw last time, but we can look at this again because we can see any particular problem with section B that the examiner has highlighted to the students who sat the exam in the previous diet. So here they say, first of all, satisfactory performance in section A, many answered the points correctly, which is good. But then, in contrast, the major problem in section B was the candidate's failure to correctly identify and address the relevant issues and rules. Okay, so let's stop here for a while. So this is very important. So imagine you have a 25 mark question. So you will need to write a bit more than in Section A questions in order to score the marks. But if you are not able to identify correctly the issue at hand for that particular question, then no matter how much you write, you run the risk that is not answering the question, and that's not what the examiner is looking for. So you may recall last time I said for the issue part, take a few more seconds, read the question again, make sure you really are addressing the relevant issue so that you are answering the question. Okay, so I think that part you can improve by practicing more. So my recommendation is when you look at a past exam question or mock exam question, treat it like a new question, and before you continue, as a way of practicing, ask yourself, what is the main issue? For some questions, quite often, there are more than one issue, maybe two, maybe three. So at the beginning, it's good practice to ask yourself, okay, what are those two or three issues? Okay, by practicing, you get better at doing that so that when you face the actual exam and you see a new question, you're much better at identifying the relevant issue. Okay, so that's step number one, but that's very important. Why is it important? Because that would directly affect the next part, the rules, the relevant rules. If you are not able to correctly identify the relevant issue, then most likely whatever rule you write down will not be relevant to the question. So that's why it's step by step. It's very important first to work out what is the relevant issue and then work out what are the relevant rules. Now, the good news is once you have worked out the relevant issue at hand, that can narrow the scope for you. There are so many topics for company law, but the good news is once you have identified which relevant issue is at hand for this question, then you already know which topic, and therefore you know which are the relevant rules for that topic. So it helps narrow down the scope for you. So once you have done that, you can explain the rules and hopefully already halfway there. If you are able to identify correctly the relevant issues and explain the relevant rules, that's almost half of your answer, which is the good news. Okay, so I cannot tell you exactly how many marks, but I'm sure it's around almost half. So I think that's the good news. You already done half of your answering. Okay, the other half, of course, is application. But I think issue and rules is a very important start. So let's continue with the examiner's comments. Many of the candidates simply repeated the facts as outlined in the scenarios without providing any explanation or discussion and with no reference to relevant rules. So this is a common habit of many students or candidates sitting exams. Okay, they just copy, meaning they copy the story again, they copy the question again. But think about it. How can you score marks in an exam? It's by answering the question. So that's why I rarely ever copy the question and I rarely ever copy any facts. The only time I would write down part of the question is in identifying the relevant issue, because quite often that's part of the question. Okay? And the only time I would mention the facts is if I need to discuss why that's the relevant issue, or more importantly, in the application section, when I apply the relevant rules to the relevant facts to get my answer. That's when I talk about the facts. So I would never write and repeat the facts just for the sake of doing that, or for the sake of making sure I have enough words in my answer, because rarely repeating the facts or repeating question will score you much marks. Okay? So let's continue with the examiner's comments. Candidates are reminded that they can only achieve good results if they correctly identify most of the relevant issues that relate to each question. So this is the one I was talking about. Is most Section B questions, I skimmed through all the different past exam questions. Generally speaking, two issues. Okay, generally, two or three. Depends on the question. Okay, so that's why it is important at the very beginning to read the question carefully and then ask yourself, what are the main issues? In most cases, it's 1 or 2. Sometimes it's 3. So that's why if you can already identify 1 or 2 issues at the beginning, you're doing very well. Okay? So now, candidates are also expected to demonstrate their analytical skills when answering questions, especially in the elective questions in section B. So what does it mean by analytical skills? So I think that happens in the application section, okay, of your answer. This is where some of the facts you need to analyze a bit more, discuss a bit more in order to reach your final answer. Okay, sometimes it's not very straightforward. It's not 1 plus 1 equals 2. It's more like you look at it, it's a bit more complicated. I need to explain a bit more, analyze a bit more before I get to my final answer. So if you can do that, wonderful. Okay, but I think it's important to do it in a step-by-step way. If you're able to identify correctly the relevant issue, if you're able to explain correctly the relevant rules, and you can apply it to the relevant facts, you've already done very well. And for an exam with limited time, I think that's already most of the questions. Okay, and if you can also do some additional analysis, even better. Okay, but I think that's something on top to make your answer even better. But never forget step number 1, 2, 3 before you do the analysis. Issue, rules, application. Okay, so now let's look at each one of these questions one by one, starting with question 6 of the June 2024 exam, section B. So we have a company called Dream Cars Limited. It sells second-hand car, incorporated in 2022 with issued share capital of 60,000, divided into 50,000 ordinary shares at $10 and 1,000 preference shares issued at $10. So you can see the share structure immediately. Okay, you can see number 1, there are 2 classes of shares. For most companies, they only have 1 class, ordinary shares. But here already you can see 2 classes of shares. So that should help you narrow down the topics already. Okay, then we have Joe and Flynn are the only directors, and they hold 2,000 and 2,500 ordinary shares respectively. Okay, so you can see there are only 2 directors, Joe and Finn, but they hold some ordinary shares as well. So remember how many shares in total? There are only 5,000 ordinary shares. So even though they only hold 2,000, 2,500, that's most of the 5,000 shares. The remaining 500 shares is being held by Darren. Ahmed owns all of the preference shares. Okay, so all the shares have been paid up and share certificates have been issued. So you can see we have 2 directors, Joe and Finn, 1 shareholder only of ordinary shares, Darren, and Ahmed is the preference shares holder, owns all of the preference shares. So that is quite important for your analysis of this question. Now, the model articles of association for private companies limited by shares have been adopted with the following additional clauses. So this is the sample articles that's provided with the company's ordinance. And as you may recall, I mentioned last time, you are free to adopt that as your company's articles. In addition, you can also add or subtract or amend the clauses in the model articles as long as the change do not contravene the company's ordinance, it is okay. So the first additional clause is directors have unrestricted power to allot shares. And number 2, the holders of preference shares are entitled to a 5% preferential dividend and to vote at class meetings only. Okay, so already you can see what are the rights of the preference shareholders. Number 1 can get 5% preferential dividend, and number 2 can only vote at class meetings. That means cannot vote at the general meeting. Okay, so the ordinary shareholders will have vote in general meeting. For this company, preference shareholders do not. So they are entitled to a return of capital on a winding up in priority to ordinary shareholders. Okay, so here you can see is preference shareholders normally their dividends get paid before ordinary shareholders. That's the norm. Here is also specified if there's a situation of return of capital, the preference shareholders also have priority over the ordinary shareholders. Okay, so the business was very successful and Dream Cars was planning to buy more cars. So in order to raise funds for expansion, in June 2023, the board decided to issue another 5,000 ordinary shares. All of them were allotted to Joe and Finn's family members. Darren, who was also interested in buying these shares, was unhappy with the allotment. So you can see we have an allotment of shares situation. So this should already narrow down the topic for you. So if I was sitting this exam paper, next to this paragraph, I would probably write down allotment of shares on the right-hand side, just to remind myself. So on the 8th of December, Darren sold all 500 of his shares in Dream Cars Limited to his friend Peter. He immediately requested the board register the transfer of shares. However, on the 12th of March, the board refused to register the transfer without giving any reason. So here you can see, number one is about a transfer of existing shares, and number two is about the board refusing to register the transfer. So this is a small topic by itself already, so I will probably write it down next to it as well. So since February 2024, Dream Cars has been struggling financially because of serious cash flow problems. So at the most recent board meeting, the directors agreed that the dividend payable on the preference shares was too high and the company should pay Ahmed and cancel the entire class of preference shares. Ahmed is unhappy with the proposal and is considering challenging the board decision. So you can see here is about a situation where the board voted basically to cancel all of the preference shares. And you can also see Ahmed being the only holder of preference shares in the company. He is unhappy and obviously disagree with the decision and he wants to challenge the decision. So by the time you get to here, I think you should already be able to guess the different topics that will be examined. Number one on the allotment, number two on refusal to register transfer, and number three about the cancelling of the preference shares. So looking at the question is in part A and part B. Part A, advise Darren on the allotment of shares and the board's refusal to register his transfer of shares. So we already can guess part A is the first two questions. And so part B is advise the board on the legal procedures for paying Ahmed off and for reducing the company share capital. So you can see basically there are three issues, two in part A and one, I guess, also broken down in two for part B as well. So let's now look at this more closely. The topics being examined, you can see allotment of shares, refusal to register transfer, capital maintenance, and reduction of share capital. They're all from Learning Outcome 4. So by practicing this question, it will help you revise these topics in Learning Outcome 4. So examiner's comments. So what I have done is extract the relevant part rather than copy and paste the whole passage, all the paragraph, because I think it's too much. So it should be easier to read using these extracted point forms. So the good news for part A, most candidates correctly explain the relevant rules. So you can see the rules for allotment of shares, rules for refusal to register transfer, they all did well. However, only a few pointed out that the article is in breach of section 140 and is therefore invalid. So you may recall there's a clause, additional clause added to the model articles by this company. So we need to discuss that as well. For part B, most candidates correctly explained section 211 about the reduction of share capital, but only a few correctly identified the issue of variation. Is there a variation of the rights of the class of holders of that particular class of shares? Okay, so let's now work through this one issue at a time. So for part A, the first issue I believe would be about the allotment of the 5,000 ordinary shares. So this will be the relevant issue. So now, relevant rule, since I already know it's about allotment of shares, clearly it will be section 140. So we said, except in accordance with 141, the directors of a company must not exercise any power to allot shares in the company. So this is the general requirement. You cannot do so unless you have the approval in section 141. So the directors of a company may exercise a power to allot shares in the company if the company gives approval in advance by resolution of the company. Okay, so the requirement is the directors need the shareholders' approval in advance. What is the threshold requirement? Is by resolution. So that means ordinary resolution. That means a simple majority, more than 50%. So if you can get 51% of ordinary shares voting, approving, that is sufficient. If you have 50.1%, that should also be sufficient as well. Okay, so continuing with the rules is so approval may be given for a particular exercise, may be unconditional or subject to conditions. So it depends on the shareholders when they're voting. Are they saying this one time you can allot shares, or you can continue to allot shares as you wish, or you can only allot shares subject to some conditions. So it's up to the shareholders. However, the approval do not last indefinitely. Okay, so under subsection 3, the approval expires if the company is required to hold an AGM basically by the end of the next AGM. Okay, if the company is not required to hold an AGM, basically not more than 12 months after approval was given. So you can see there's a time limit on the approval. Why? Well, you can think about it as a good way to protect the shareholders. If after every once in a while, for example, after every 1 year, if the directors need to come back to the shareholders to ask for approval to allot shares, it gives the shareholders a chance to review what was done and to decide whether to continue to give that power to the directors. So it makes sense having this limited approval period. Okay, we've now finished identifying the relevant issue. We've explained the relevant rules. We can now apply them to the facts of our story in order to answer the question. So applying section 140 and 141, directors may not exercise their power to allot shares in the company without first obtaining approval from the members in advance. So why is that important? Well, let's look at the clause. The additional clause in the article states that directors have unrestricted power to allot shares. So you would want to ask the question, is it possible with this additional clause that directors do not need to ask for approval when they allot shares because they already have the approval in the articles? The answer is no. Why? Because that clause is in contravention of section 1413, which states approval granted will expire by the next AGM, or if no AGM is required, not more than 12 months. Therefore, the clause is invalid, so the directors should have obtained approval from the members in advance, basically in accordance with section 140 and section 141. So that would already be a good answer. That is some application. But your answer will be even better if you refer to the facts provided. Since Joe and Finn together holds 4,500 out of 5,000 shares, they should have sufficient votes to pass the ordinary resolution. So take a look, 4,500 out of 5,000, that's 90%. Remember, ordinary resolution, you only need more than 50%. So it looks like they would have enough votes to pass the ordinary resolution to allow the directors to allot shares if they want to. Okay, so we're finished talking about the first sub-issue of Part A. We can now move on to the second sub-issue, refusal to register the transfer of shares. So there are a number of sources we can refer to. First of all, model articles. This is the one adopted by the company. In particular, Articles 2, subsection 2, the directors may, in their discretion, refuse to register the transfer of a share. So you can see it is within the powers of the directors to refuse to register a transfer. That will be a starting point. Okay, then we can go to section 151 of the company's ordinance. The transferee or transferor of shares in a company may lodge the transfer with the company. Then, within 2 months after the transfer is lodged, the company must either register the transfer or send the transferee and the transferor notice of refusal to register the transfer. So you can see the way section 151 works is the mechanism allows for two possibilities. Either the directors will register the transfer, or number two, the directors refuse to register the transfer. But no matter which one, there is a timeliness. Within 2 months of lodging the transfer of the company, the directors must either do the registration or notify basically the applicant, the transferee and the transferor, notice of refusal. So things will not be delayed indefinitely. There's at least some defined period of time in which they must respond. And then what happens if the company refuses to register? Well, the transferee or transferor may request a statement of the reasons for refusal. And upon receiving such request, the company must, within 28 days, either send the statement of reasons to them or register a transfer. So you can see it's quite interesting. Here and previously in subsection 2, despite any possible disagreement in which the directors refuse to transfer, at each step of the way under section 151, there's always a chance for the directors to simply register the transfer, then there will be no disagreement. Okay, but even at this stage in subsection 4, if the directors for whatever reason still feel they do not wish to register the transfer, then you must provide a statement of the reasons. And subsection 5 is the company and every responsible person, if they do not follow the requirement in subsection 2 and subsection 4, that is basically replying within 2 months and also provide the statement of reason within 28 days, then commit an offense, get a fine at level 4, which I think is $25,000, and then continuing offense, meaning if you still do not comply, then a further fine of $700 for each day. So if you continue not to reply, then you get the fine of $700 extra per day. So that can add up to a large amount. Okay, so now that we have all the relevant rules at hand, we can apply to our story. So in this case, Darren sold his shares to Peter on the 8th of December, immediately requested the board to register a transfer. However, on the 12th of March, 3 months later, the board refused to register the transfer. So assuming Darren has done what he should do, what he's supposed to do under subsection 1 of section 151, and that is lodge the transfer to the company and therefore should include the proper instrument of transfer, then the company should, under subsection 2, either register the transfer or notify Darren of the refusal to register a transfer, I guess, within 2 months. Now, in this case, that means they should have notified Darren by the 8th of February 2024. In our story, they only notified the refusal on the 12th of March, 3 months later, so 1 month longer than they should. So in that case, that's a contravention of section 151, subsection 2. The company and every responsible person, so likely to be Joe and Finn, will be liable to a fine at level 4 and a further fine of $700 per day. Okay, so you can see the good thing about section 151, it does not force the directors to make a decision, but it does force the directors to act. In subsection 2 is to notify the refusal, and in subsection 4, if requested, to send the statement of reasons for refusal. Okay. Okay, so now we can discuss a bit more about the refusal. So, do the directors have a right to do that? And how far would that power go for these directors? So, for reference, you can refer to this court case, which says directors should fairly consider whether to register the transfer at a meeting of the board, and that in the absence of evidence to the contrary, the court would assume they had acted reasonably and bona fide. So this is respecting the wishes of the company, because the company in its articles granted the directors the power to refuse to register a transfer. So with such a power, obviously they should consider each request fairly. That means look at it, consider and discuss, and if possible, of course, they should deal with it in a straightforward manner, and that is register a transfer. So if they do that, generally the court will not interfere. They will just assume the directors have acted reasonably and bona fide, in good faith. However, if there's evidence to show that the directors have exercised their power capriciously and unfairly, the court will have jurisdiction to interfere. Okay? So generally speaking, if the members in the articles gave the directors the power to refuse registration, then it's up to the directors to exercise that power properly. The court will usually assume that's the case. Okay? So application. Darian should first obtain the statement of reasons for refusal from the company. So you will recall, so far Darian is only notified of the refusal to register a transfer. So Darian can apply under subsection 3, request the company to provide a reason. Then in subsection 4, the company should either register a transfer to end the matter or have to provide a statement of reasons for refusal. Okay, having that information in writing, then Darian can consider whether the directors have exercised their power capriciously and unfairly, and if so, then can apply to the court under Section 152. So it's a step-by-step process, and that's the reason why Section 151 is important, because it forces the parties to move down the step, go through the procedure, and not allow undue delay, so that you can either the transfer will be registered, or at least you get a statement of reason for refusal, so you can know what you must do. Is there some information you need to provide? Is there some concern? Can you do something, provide some information to allay the concerns of the board of directors? If so, everyone is happy, okay? But if they're acting unreasonably, or if they're exercising their power capriciously and unfairly, then at least you have Section 152 and can apply to the court. Okay, so now we can move on to part B of the question, looking at the first sub-issue. So what are they trying to do? They want to cancel the preference shares. So by canceling the preference shares, they're removing it, I guess, from the share capital, or I guess it's a reduction of share capital. So that's why that will be the first sub-issue you want to discuss. So looking at this court case, is that paid-up capital may be diminished or lost in the course of the company's trading. That is a result which no legislation can prevent. But persons who deal with and give credit to a limited company naturally rely upon the fact that the company is trading with a certain amount of capital already paid, as well as upon the responsibility of the members for the capital remaining at call. And they are entitled to assume that no part of the capital has been paid into the coffers of the company, has been subsequently paid out, except in a legitimate course of its business. So what is this talking about? Well, imagine you're dealing with a company and you give credit to a company. For example, you're a supplier. You sell goods to a company. Usual practice is you deliver the goods today and the company will pay you next month. You have 1 month or 30 days credit. That's very common. Now, you would only do that if you're confident. You're confident that the company can actually repay you. So you're assuming the company has enough money to repay you as the debts fall due. So share capital represent the money that was invested into a company by the shareholders. So as explained by the judge in this case, it's understood some of that money will be used as an expenses or part of the business loss. It is okay. But for the remaining amount, it should stay in the company so that if necessary, can be used to repay the creditors, repay the suppliers. Okay? So that's the reason why reduction of share capital is an important topic, because they want to make sure the creditors are protected. So looking at Section 210 of the Companies Ordinance, subsection 1, a company may, in accordance with procedures in Section 211, reduce its share capital. So based on our company's ordinance, you are permitted, or a company is permitted to reduce the share capital, but only if you follow the procedures in Section 211. But there are some conditions in subsection 2 and 3. So subsection 2 is a company must not reduce its share capital if, as a result of the reduction, there would no longer be any member of the company holding shares other than redeemable shares. Okay? So if you keep reducing the share capital to the point there's no more members, no more shareholders, then how can anyone deal with the company? There's no one anymore. There's no more members. Okay? And subsection 3 is this division is subject to any provision of a company's articles that prohibits or restricts the reduction of the company's share capital. So of course, you may recall I mentioned last time in part 1 is sometimes in our legislation, in our company's ordinance, it would refer to the company's articles. It will say, this is the rule based on our company's ordinance, but for this particular matter, also look at the company's articles. See if there's any clause here that prohibits or restricts the reduction of the shares capital. Okay, so you can see under 210, a company is permitted to reduce share capital as long as you follow the procedures in 211. But you also need to look at your articles, your company's articles, to see if there are any additional prohibition, which means you're not allowed to reduce capital, or restrictions, meaning you can reduce, but here are some extra conditions. So let's look at section 211. Basically, if you want to reduce the share capital of your company, there's two methods you can use, one or the other. So subsection A is by resolution, supported by a solvency statement. So that is generally known as the court-free approach, meaning there's no need to involve the court, usually, okay? The second approach, of course, is you need to involve the court, which is by special resolution and confirmed by the court. So that's the two possible paths you can take. And if you decide to use the first one, then you need to know what is a solvency statement. That is explained in section 206 of the company's ordinance. A solvency statement in relation to a transaction is a statement that each of the directors making it has formed the opinion that the company satisfies the solvency test. Okay, so that's the requirement. And in forming an opinion for this purpose, a director must inquire into the company's state of affairs and prospects and take into account all the liabilities of the company. Okay, so you can see it's a strict requirement. Number one, you want the directors to form an opinion if the company passed the solvency test or not. But in forming an opinion, you cannot say, I declare yes. The director must be careful in making or informing that opinion. Must, number one, inquire into the state of affairs of the company. So you must check how well is the company doing? Is it really solvent? And you can see state of affairs and prospects. Prospects means forward-looking, looking into the near future of the company. Is it doing well? And part B, take into account all the liabilities, all the money that is owed by the company to outsiders. Okay, so what is the solvency test? So a company satisfies the solvency test if part A, immediately after the transaction, there will be no ground on which a company could be found to be unable to pay its debts. Okay, so it's very important to show that by doing this particular transaction, for example, reduction in capital, would not result in a situation where the company cannot repay its debts. So if you took all the money away and cannot repay its debts, you already failed the first part of the solvency test. The second part, so since this is not a winding up matter, we can go to subsection 2. The company will be able to pay its debts as they become due during the period of 12 months immediately following the date of the transaction. So this is forward-looking, okay? That's why you need to look at the prospects of the company. It's in the future, in the coming 12 months, the company will be able to pay its debts as they fall due. So if you're able to do that, then you can sign off on the solvency statement. But Section 207 is basically a deterrent effect. You want to make sure the director are careful in making such a declaration, in issuing such a solvency statement. So a director who makes a solvency statement without having reasonable grounds for the opinion expressed in it commit an offense and is liable on conviction on indictment to a fine of up to 150,000 and imprisonment of up to 2 years. So you can see it's quite serious. Obviously, because you want to make sure the directors are very careful, that's why they need to inquire into the company's financial status, into the prospects, and consider all the liabilities before they form the opinion to make such a statement. Okay, so we have now gone through the relevant rules. We can now apply them to our story. So in this case, the cancelling of the preference shares would result in a reduction of the company share capital. So as explained in the court case, the doctrine of capital maintenance is important to protect the interests of those dealing with the company. So imagine if you're the supplier, you give credit to the company, you sell goods and allow the company to pay you next month. Imagine if the capital is not maintained. If they can freely reduce the share capital, pay all the money back to the shareholders before they settle all their debts, then that would not be in the interest. So that's the reason why we have the doctrine of capital maintenance. So reduction of capital is permitted under Section 210. And now, most important, assuming it is permitted and not restricted by the company's articles. Okay, this is one of the conditions in subsection 3, is assume there's no such restriction in the company's own articles. So since they adopted the model articles and we looked at the additional clause already, we assume there are no restrictions. So of the two methods under Section 211, most likely would use the first one under subsection A, and that is by a special resolution supported by a solvency statement. So for the solvency statement, the directors, so it will be Joe and Finn, will have to make a declaration that the company can pay its debts as they fall due in the coming 12 months. So in our story, it says the company is struggling financially because of serious cash flow problem. So they need to check carefully to make sure they really can make the declaration, they really can issue the solvency statement. Otherwise, they may risk the penalties as explained in Section 207. Okay, we can now look at the second sub-issue for Part B. By cancelling the preference shares, would that amount to a variation of class rights? Okay, so this is an important question because if the answer is yes and are met, the holder of all of the shares, all of the preference shares, that may cause some problem for the company. So that's why we need to analyze and discuss this particular sub-issue. So the relevant rules for variation of class right will be Section 180. Rights attached to shares in a class of shares in a company may be varied only Part A in accordance with provisions in the company's articles, or if there's no such provisions with the consents of holders of shares in that class. And the consents required is a written consent representing at least 75% of the total voting rights of holders of shares in the class, or a special resolution passed at a separate meeting of the holders of the shares in the class, sanctioning the variation. And the court case you may want to look at is House of Fraser case. The cancelling of preference shares involved the fulfillment and satisfaction of the contractual rights of the shareholders, including the return of capital in priority to other shares, which would not amount to a variation of rights. So what it's saying is, if that is part of the agreement, so you can understand the agreement is to issue preference shares in return for some money. It's sort of like borrowing money. But if it's already part of the deal, part of the agreement that at some time there will be a return of capital, and in the case of preference shares, they will get it in priority to other ordinary shares, then it's just following the agreed steps, the contractual rights of the parties involved in the preference shares. In that case, that would not amount to a variation of rights. So let's apply that to our situation. Here, the cancellation of the preference shares are usually part of the contractual agreement to return capital in the event of cancellation. Okay, so let's take a look back at our story. Okay, so let's look at the additional clause number 2. Okay, the holders of preference shares are entitled to a 5% preferential dividend and to vote at class meetings only. They're entitled to a return of capital on a winding up in priority to ordinary shareholders. So at least you can see it is understood that return of capital would be envisaged at the beginning. Sooner or later that would happen. Of course, this is talking about winding up, but at least it's saying if it did happen on a winding up, you get priority to ordinary shareholders, meaning you will get the return of capital before the ordinary shareholders. So let's go back to our part, answering our part of the question. Okay, so as such, that would not amount to a variation of class right, and therefore consent by holders of preference shares under Section 180 would not be required. So you can see this part is important to discuss, because if the cancelling of the preference shares amounted to a variation of the class rights, then you must go to Section 180, and then you will need to get the consent of holders of preference shares. Since Ahmed holds all of the preference shares, and since he has already said he does not agree, you will not get the required consent. So that's why this part we need to discuss. Okay, so we have now finished looking at question 6. We can now move on to question 7, and we can first look at the story. So we have a company called Ocean Limited, and you can see here it has share capital of 100,000, and these people, you can see they are the only directors, Sophia, Owen, and Lynn, and they hold 1,000, 1,000, and 2,000 ordinary shares respectively. So Jasmine holds the remaining 6,000. So you can see there are 3 directors holding some ordinary shares, and then you also have 1 shareholder, Jasmine, who hold a majority of the shares. So Ocean has adopted the model articles with the following additional clauses. Directors cannot be removed without their prior consent, and Ocean Limited can, by passing an ordinary resolution, require a shareholder to sell his or her shares to the other shareholders of the company at a fair value. Okay, so the second one is talking about whether you can require, in a way, sort of like forcing a shareholder to give up his or her shares to the other shareholders if you have enough votes. And the threshold is ordinary shareholder, ordinary resolution, so it's not a high threshold. As long as more than half of the voting rights said yes, then that particular shareholder will have to give up his or her shares, but it will be sold at a fair value. So in January 2024, Owen was one of the directors, was in negotiation with Green Tech Limited to purchase 20 new computers for its office. At a recent board meeting, all three directors approved the contract to purchase the computers. Owen holds 30% of the shares in GreenTech, but he did not mention this to Sophia or Lynn. Okay, so you can see Sophia, Owen, and Lynn are the directors. So when they hold a board meeting, the three of them would attend. This is a contract to buy computers from GreenTech Limited. And turns out Owen owns 30% of the shares in GreenTech, but he did not mention, he did not disclose to the other directors. So Sophia and Lynn later found out that the market price for these computers was only 150,000. So you can see the contract signed was for 200,000, but turns out the value of the computers only 150,000. So where did the remaining 50,000 go? Well, it turns out Owen received a commission of 50,000 from GreenTech. So you see clearly something not right here. Something not right done by one of the directors here, one or more of the directors, I should say. Then, in February 2024, Owen asked Sophia and Lynn whether he could borrow 300,000 from Ocean Limited. Sophia and Lynn approved the loan at a board meeting, but without asking any questions. Jasmine was not aware of the loan. So here you can see it's a loan to a director. You can see that it was approved, but the remaining shareholder, Jasmine, was not aware of the loan. Then in March 2024, Jasmine discovered that Owen had set up his own property management company in the same local area. So Owen Limited is in the property management business, and the company set up by Owen also in the property management business and is in the same local area. So Jasmine, Sophia, and Lynn are now considering removing Owen as a director and buying his shares in Ocean. However, Owen has refused to sell his shares. So you can see so far in the story is some directors may be doing something not that correct. So it's possible we talk about directors' duties, and then we're talking about a loan to a director, and we're talking about removing a director, and also asking Owen to give up his shares as well. So what are the questions? Part A, have the directors of Ocean Limited breached any of their duties as directors of the company? If so, what are the consequences? So you can already guess that will be one of the main issues you will need to discuss. It's plural because we're dealing with directors' duties of more than one director. So what are the legal procedures for removing Owen from the board of directors and for purchasing his shares in Ocean Limited? So that will be the issues in part B. So let's now look at first the examiner's comments. Director's duties will fall under learning outcome 2. Removal of a director and the articles, clause in the articles is learning outcome 2 and learning outcome 1. So for part A, most correctly referred to relevant rules and concepts. So you can see that's an improvement. They have done quite well on that part. However, many candidates confuse the concept of providing financial assistance to a person and making a loan to a director. So you can see there are different provisions in the ordinance. One is about financial assistance, which is not permitted. There are some restrictions, I should say. And number 2 is about making a loan to a director. Part B, most candidates correctly explain the procedures to remove a director, which is good, but only a few were able to explain the concept of the share expropriation clause and the procedure for amending the articles. So that is the part is whether the clause requiring or forcing a shareholder to give up the shares, whether that will be valid or not, and whether any amendment is required. So let's focus on part A, on the director's duties on the purchase of the 20 new computers in which Owen owned 30% of GreenTech and in which he received 50,000 commission. So the starting point will be section 536 of the company's ordinance. If a director of a company is in any way interested in a transaction with the company that is significant in relation to the company's business and director's interest in material, the director must declare the nature and extent of the director's interest to the other directors. Okay, So you can see this is the requirement of 536. If you're a director and you have an interest in a transaction, you need to disclose basically to the board of directors. And 542 is a director who contravenes 536, commits an offense, and is liable to a fine at level 6. Okay, so again, the fine is quite high. Level 6 is $100,000. Okay. Also, the court case I believe is relevant will be Aberdeen Railway. Director of a company with interest with the other contracting party must disclose to the company as there would be a conflict of interest. So imagine if I am representing my company for a contract to buy some goods from another company. If I have some interest in that other company as well, automatically there will be a conflict of interest. Because when I'm doing the negotiation, am I negotiating on behalf of my company or am I negotiating on behalf of the other company? That would clearly be a conflict of interest. Okay, so application, apply all those to our situation. So in this case, Owen holds 30% of the shares in Greentech Limited. He should have declared its interest to the board as per section 5361. His failure to do so, because clearly he did not do so, may result in a fine at level 6 under 542 subsection 1. Further, by negotiating on behalf of the company in the purchase of computers from Greentech, a company which he holds 30%, there would be an inherent conflict of interest. So as explained in Aberdeen Railway case, it would not be known whether he was acting in the company's interest or that of Greentech when he negotiated the price for the purchase of computer. The contract is therefore voidable. So the final price negotiated was $200,000. So was it negotiated in the interest of the company or was it negotiated in the interest of Greentech or something else? So when they subsequently found out that the market price of computers was only $150,000, you can see clearly that conflict of interest did arise when he was doing the negotiation. Okay, so director's duties with the $300,000 loan to Owen. Okay, so you can see under section 500, without the prescribed approval of its members, a company must not make a loan to a director of the company. So if you are asking to make a loan to a director of the company based on section 500, you need to ask the members for approval. And section 505 is an exception where you do not need to ask for approval. It's if the aggregate value of the transaction, the loan, I guess, is actually do not exceed 5% of the value of the company's net asset, or if you do not have the information available, for example, the latest financial statement not yet ready, then the amount of the company's called up share capital. So using either item or either measure cannot be more than 5%. So if it's less than 5%, it is okay. And then under section 513 is if a company enters into a transaction in contravention of section 500, the transaction is voidable at the company's instance. Okay, so since you should not have entered into a transaction because you did not get the approval or it's not less than 5%, then of course the company can choose not to go ahead with that transaction. It's voidable. Okay. Unless restitution is no longer possible, because it may not be possible to reverse the situation, the company has been indemnified of any loss or damage. So even though this is not something the company has agreed, but if any loss or damage already indemnified, meaning someone else will bear the loss or damage, then it is okay. Or a person other than the director for whom the transaction was entered into acquired the rights in good faith, full value, and without actual notice of the contravention, those rights will be affected by the avoidance. So it's very common under our law to protect the subsequent bona fide purchaser that was acting in good faith, who purchased the goods for value, meaning pay money for those goods, and without actual notice or contravention. So if someone falls into that category, then the answer is you want to protect them, since then the transaction cannot be cancelled. And then, of course, you still want to know, no matter if the transaction has been avoided or not, the following persons will have to be liable to account to the company for any gain, and also to indemnify the company for any loss or damages. So this is all part of acting in the interest of the company. So if you did something that's not approved by a company, if you turn out to have any gain, you need to pay that gain to the company. But if there's any loss, then you need to indemnify the company, meaning you will have to bear the loss. So who are those people? You can look at section 513, subsection 3, and it will include a director of the company. So application, apply all that to our story. So here, Sophia and Lynn approved the loan to Owen at a board meeting. And Jasmine, the majority shareholder, was not aware of the loan. So as such, it's likely they did not obtain the approval of members as required by section 500, subsection 1. Okay, so you may try to argue, do the exemption applies under section 5051? Well, it will only apply if the transaction did not exceed 5% of company's asset or share capital. So since Ocean Limited issued share capital was $100,000, the $300,000 loan would far exceed the 5%, therefore no exemption. So you need the approval from the members is required. So under section 513, the transaction is voidable, and Owen, Sophia, and Lynn as the directors would be liable to account to the company for any gain and liable to indemnify the company for any loss or damages under subsection 2 and 3. Okay, the next sub-issue to discuss in terms of director's duties is the $50,000 commission received by Owen. So based on the Regal Hastings case, a director has a duty not to make a secret profit. So directors are acting for the company and should be acting in the interest of the company and should not be using that position to derive some secret profit for himself or herself. So very common is if you have a situation where you may benefit from a transaction, you will need to declare to the company beforehand and get approval. So in this case, Owen received $50,000 commission from Greentech after the purchase of the 20 computers. Since Owen did not disclose to Ocean Limited, he will be required to account for profits, meaning the $50,000 needs to be paid to the company. Okay, so what about Sophia and Lynn? Did they breach any of their duties as directors of the company? So for this particular situation, I think we can refer to section 465 of the company's ordinance. A director of a company must exercise reasonable care, skill, and diligence. So that's the duty. So what does it mean by reasonable care, skill, and diligence? It means the care, skill, and diligence that will be exercised by a reasonably diligent person. First, with the general knowledge, skill, and experience that may reasonably be expected of a person carrying out the functions carried out by the director in relation to the company. Okay, so part A is sometimes known as the objective test. So what it's saying is this is what we normally expect of a reasonably diligent person acting in your capacity as a director of that particular company. That's the level of knowledge, skill, and experience, the care, skill, and diligence we expect. Okay? Part B is the subjective test. General knowledge, skill, and experience that the director has. So maybe that director has more knowledge, more skills, and more experience, then the expectation can rightly be higher. Okay? So that's why for the duty to exercise reasonable care, skill, and diligence, the minimum requirement is the objective test. The requirement can be higher based on the subjective test if you happen to have more knowledge, more skills, and more experience. So in this case, Sophia and Lynn breached their duty to exercise reasonable care, skill, and diligence under section 465 as they approved the loan to Owen without asking any questions. So as members of the board of directors, when they receive a request for a $300,000 loan $300,000 loan to a director during a board meeting, they should at least have asked some questions to find out why you need the loan and to think about it carefully whether they should use the company's money to lend to the director. Okay, so what about Owen setting up a competing business? So I think, again, the Aberdeen Railway case would be relevant because maybe there may be a conflict of interest. I also think the Cook and Dees case is relevant because the director of a company has a duty not to usurp the corporate opportunity of a company, not to take away the opportunity of your company in favor of another company. Okay, for example, a company that you own. So in this case, Owen set up a competing business in the same local area. So you need to ask whether there was any conflict of interest when Owen was handling a transaction relating to Ocean Limited. So for example, if Owen as director represented the company in any transaction, did he act in the interest of Ocean Limited only, or was there any conflict of interest? So very similar to the purchase of computer from Greentech, you can see there was a conflict of interest. Also, whether there were any opportunities which he took from Ocean Limited for his own company. So since both companies are working in the same business area, property management, and operating in the same local area, so you have to ask the question, did any contracts signed by his own company, any deals, any business, did they belong to Ocean Limited? And did Owen somehow give that opportunity away to his own company? If so, then he would have breached his duty not to usurp corporate opportunity from Ocean Limited. Okay, we can now move on to part B of the question. First sub-issue would be about the removal of a director because they want to remove Owen. So section 462 of the company's ordinance, here it says a company may, by an ordinary resolution passed at a general meeting, remove a director, despite anything in its articles. So it's basically saying the company can remove a director, and the threshold is not high. It's only by ordinary resolution, meaning all you need is more than half of the votes. And then pass at a general meeting, so it must be a general meeting of shareholders. But there's a requirement on special notice under subsection 4. So if you want to remove a director in a general meeting, obviously you need to send out a notice to call the general meeting, but there's special notice requirement if you want to remove a director. And it explained here basically is the company must send a copy of the notice to the director concerned. So you cannot do it secretly. If you wish to call a meeting of shareholders to remove a director, you must let that director know. And that director is entitled to be heard on the resolution at the meeting in which the resolution is voted on. So during the general meeting, when the shareholders are deciding whether to vote yes or vote no, obviously that director is entitled to be heard. He or she can state his or her case. So if the notice, maybe the director may make a representation in writing to the company. So that's why when they circulate the information to members, his written statements can also be circulated to the different members as well. So application, apply that to our story. In this case, as Jasmine, Sophia, and Lynn together holds 9,000 out of 10,000 shares, they will be able to pass an ordinary resolution to remove Owen as a director under section 4621. So clearly, the ordinary resolution, the threshold would not be a problem since they own most of the shares, 90%. So to get more than 50%, I think that'll be easy. Nonetheless, they need to comply with the special notice requirement. So that's why they need to allow Owen to know about the calling of the meeting, allow him to attend, allow him to make representations to all the shareholders. But of course, no matter what representation he makes to the three of them, since they have already decided, it will be unlikely to change the outcome. Now, what about the additional clause? It says directors cannot be removed without their prior consent. So this seems like a powerful shield for any directors that people are trying to remove. But you can see maybe that would not help him. Why? Because you can see section 4621, what does it say? It's basically saying that a director can be removed despite anything in its articles. So it is unlikely that the additional clause can help Owen to prevent his removal as a director of a company. Okay, the second sub-issue under Part B of the question. This is the share expropriation provision. The clause which says that if you have enough votes, you can force or demand a shareholder to sell his or her shares back to the company, but at fair value. So the relevant principle from court case, I think, would be the one from Allen and Gorees, which says the powers to alter the article should be exercised bona fide for the benefit of the company as a whole. So the directors can propose amendment to the articles, but must exercise that power in good faith for the benefit of the company as a whole. Then the next case is talking about adding a clause to the articles, give unrestricted power to expropriate any shareholder would be too broad and goes beyond bona fide for the benefit of the company as a whole. So in that particular case, the clause the court decided was too broad. The powers are too broad. In that case, it would seem when they use that clause, it may go beyond just in good faith for the benefit of the company as a whole. So if you draft a clause too broad, then you may allow them to use it for purposes beyond just for the benefit of the company as a whole. So in Sidebottom case, they added a clause to the articles to require a shareholder which carried on a competing business to sell back the shares at full value was held to be bona fide for the benefit of the company as a whole and enforceable by the majority against the minority. So this case is a good example where if a clause is not too broad, where it has a specific situation which allows the company to require the shareholders to sell back the shares, that would be held to be, I guess, acceptable, and they would decide that would be bona fide for the benefit of the company as a whole, and therefore it will be enforceable, meaning the court will allow them to use that clause, even if it is done by the majority against the minority. Okay, application. So in this case, the additional clause in question, what does it say? Ocean can, by passing an ordinary resolution, require a shareholder to sell his or her shares to the other shareholders of the company at a fair value. Okay, so it's important to look at the actual wording of the clause in our story. So you can see there's a threshold requirement. You need more than half the vote. Then you can require that shareholder to sell the shares back to the other shareholders, but at a fair value. So it seems that here the fair value part is reasonable, but it does not say under what circumstances can they use this clause. It's basically saying there's no condition, no criteria. As long as you have enough votes, you can force a shareholder to sell his or her shares. So it is possible to argue based on the Darvin case, the clause is too broad. It does not state the specific circumstance under which the clause can be invoked against a shareholder. So if this dispute goes to court, it is likely the court will say the clause may not be enforceable. Okay, so for Jasmine, Sophia, and Lynn, what can they do? They can consider to alter the articles. Okay, what does it mean? Change this clause, the wording, maybe to add the circumstances in which a clause can be invoked, which can include the carrying on of a competing business against a company. Okay, so at the moment, the clause is too broad. It does not include the specific circumstances when they can use the clause. Now, if they add a circumstances, for example, the shareholder is carrying on a competing business against our company, that would seem to be a specific circumstances. It would seem to be a reasonable situation where you require the shareholder to sell the shares back to the other shareholders. Now, if they want to amend the articles, then you may recall under section 88(2) of the company's ordinance, they can do so but only if they pass a special resolution. So if they have enough votes and pass, it will be fine. And I think if they can pass the test under Ellen Goldreaves, that they amended the articles bona fide for the benefit of the company as a whole, then I think the clause, the amendment will stand and they can use the clause. Okay, so we can now move on to question number 8. So we have Taha, Ali, and Olivia. They are university friends who set up an IT consultancy business in partnership after graduating in 2020. The business was very profitable and they incorporated as TAO Limited in 2022. So TAO has issued 1,000 shares. Taha, Ali, and Olivia each holds 100, 300, and 600 shares respectively. They are the only directors of the company. The model articles was adopted with the following additional clauses. So you can see a shareholder who wishes to transfer his or her shares must offer them to the other shareholders of the company, and directors are entitled to an annual salary of 600,000. So the directors are considering expanding into overseas markets. Taha has had heated arguments with Ali and Olivia over the expansion plans. Following the arguments, Ali and Olivia did not speak to Taha or consult him on any of their business decisions. At a shareholders meeting in January, they voted to remove Taha from the board of directors, and Taha offered to sell his shares to Ali and Olivia, but they refused. So not a good situation. You can see here, things were very good at the beginning. They were good friends, they started the business together, they're running it together, and only subsequently did they incorporated the business in 2022. There were some arguments and then they stopped speaking to each other. So Taha wants to get rid of her shares so that she can move on, but they refuse to buy from her. So not a good situation. So TAO has not paid any dividends since it was incorporated. So this is important because if you have a business that is successful, profitable, so how will the investors get the money back? So generally, the shareholders will get the money back in the form of dividends. But in this particular company, no dividends was paid since 2022. So if you are a shareholder and you're not receiving dividends, how can you get a return on your investment? So in March, Ali and Olivia voted to increase their own salaries from 600,000 per year to $1 million. Okay, so that's how Ali and Olivia are getting their money back. Okay, but you can see Taha has been removed from the board of directors. That means she would not receive any of the annual salary of a director. They also voted in a board meeting to change the terms of employment in the service contract from 2 years to 5 years. So this is sort of like entrenched management, is to make a change so that they are there for a longer time, not so easy for you to remove them. So Taha has completely lost confidence in Ali and Olivia. So clearly breakdown in the relationship and mutual trust and confidence. So advise Taha on the personal remedies available to him. Sorry, Taha is him. Okay, so look at the examiner's comment. Before we do that, so the main topics we'll be looking at will be unfair prejudice and just and equitable winding up. So they are topics from Learning Outcome 3. So according to the examiner, most candidates correctly identified the relevant concept in relation to unfair prejudice remedies, but only a few of them were able to identify the relevant issue of just and equitable winding up under section 1771F. So it's interesting because I would have thought most students would have thought of just and equitable winding up when they were reading the story, because this is a classic case of a breakdown in relationship of mutual trust and confidence. So that option or that remedy would often arise, but no matter, we will go through them now. Let's start with unfair prejudice. So the starting point will be Section 724 of the Companies Ordinance. The court may exercise the power under 725 if, on a petition by a member of a company, it will consider the following. Okay, so if you want to make an unfair prejudice claim, how can you start the process? You can start it by petitioning the court. Okay, who can submit such a petition? These are the people who have standing. So for 7241 is a member of a company. So the court will consider or will exercise the power if it considers that the company's affairs are being or have been conducted in a manner unfairly prejudicial to the interests of the members generally or of one or more members. So the first one is the way they run their business has been unfairly prejudicial to the interests of one or more members. That's part A. Part B is the actual or proposed acts or omission of the company is or would be so prejudicial. So it's generally a particular transaction, a particular decision to do something or not do something. It was decided it was prejudicial, so would submit such a claim. So what can the court do if it decides there is unfair prejudice? Well, the court may make any order that it thinks fit for giving relief, and without limiting the powers granted to the court, can make the following orders. So these orders are examples of what the court can do. Number one, regulate the conduct of the company's affairs in the future. That is, change some of the way they behave. Or part B, purchase of shares of any member of the company by another member. So this is a buy order. It's ordering other members to buy the shares of the members that's complaining of the problem. Or C, purchase of shares of any member by the company. So instead of asking the other members to buy back, you can ask the company to buy back the shares from that particular shareholder, and reduction accordingly of the company's capital. And then a court case that may be relevant in this one, non-payment of dividends and increase in payment of management fees to the directors amounted to unfair prejudice to directors who was excluded from management and payment. So it's a bit similar to our situation. It's where you have a dispute, and then for some reason they stop paying dividends, but then one of the party was excluded from management and excluded from payment of the management fees or directors' fees. Then the court may see that as an unfair prejudice arrangement. So apply all that to our story. In this case, Ali and Olivia removed Taha from the board of directors. They did not pay any dividends, but increased their own salaries from 600,000 to 1 million per year. So it's possible for Taha, who is a member, to petition the court under 724 subsection 1 to make an unfair prejudice claim. So as explained in a court case, the usual remedy in this case, if the court decided or the court agreed it was unfair prejudice, would be a buyout order under 7252, either B or C. So either requiring Ali and Olivia to buy the shares from Taha. In this case, they refuse, so it's possible to order the company to buy the shares from Taha, and then of course cancel those shares. Okay, the second sub-issue for question 8, I believe, will be the just and equitable winding up. So the starting point will be section 1791 of CAP 32. So you can see it's a different ordinance. The company's ordinance we refer to the most previously was CAP 622, but CAP 32 contains a lot of the provisions relating to winding up matters. So an application to the court for the winding up of the company shall be by petition. So again, you need to start the process by petition. Who can submit such a petition? Well, many parties. Can be by the company, by the creditors, by contributory, many. Okay. But if you do submit such a petition, you must have a valid ground to ask the court to wind up the company. So a company may be wound up by the court if the company has by resolution resolved the company be wound up, company did not commence its business or suspend its business for a whole year, company has no members, company is unable to pay its debts, events specified in the articles, or if the court is of the opinion it is just and equitable that the company should be wound up. So clearly you can see ground 1F most likely is the one relevant to our story. So we have Ibrahimi and Westbourne Galleries is one of the more famous case for this particular ground, is where the members have formed a company on the basis of a relationship involving mutual trust, understanding, and confidence, which no longer exists. Okay, so that will be an example of a situation where the court will consider to wind up a company using this ground. So in this case, Taha, Ali, and Olivia started their IT consultancy business together, initially as a partnership. 2 years when the business became profitable, they incorporated their business. They started a limited liability company to continue to run their business. So it's possible to claim that they were in a quasi-partnership, even though it was in a corporate form, in a limited liability company, but the whole thing grew from the initial relationship of mutual trust, understanding, and confidence between them, in which they would jointly manage their business together. That was how it all started. Now, with a breakdown in the relationship and Taha being excluded from management, per the Ibrahimi case, it's possible to claim the company should be wound up on just and equitable grounds. So if they're no longer able to continue this quasi-partnership, then the company should be wound up, the assets should be redistributed back to the respective shareholders so they can each go their own way. So that would seem a fair resolution of a situation that has gone bad. Previously, they have a good relationship. That's how they built the business. That's how they started the company. Now they no longer have that relationship. It has broken down. They don't trust each other, and they don't even allow Taha to be part of running the business anymore. It is time for them to end the company, return the assets to each other, the money to each of the shareholders, and they go their own way. Okay, so we've finished question 8. We can now move on to question number 9 of the June 2024 exam. So we have Phoenix Limited. It's an energy company whose shares are listed on the Stock Exchange of Hong Kong. David is the company secretary, and he recently attended a board meeting held in January 2024. So during the board meeting, Sam, Director of Research, reported that his research team has achieved the goal of developing a new technology to produce renewable energy. So this marks a huge success for the company, which has been investing heavily in the research project over the past 10 years. Sam's report predicts that the company's share price will increase considerably when the news is made public. The board agreed that this information must be kept confidential until the company officially announces it on its website. So hopefully, by the time you have finished reading the second paragraph, you can already guess most likely which issue would be relevant to this question. A listed company, inside information, if released to the public, can affect the share price. I think clearly, unless we see something very different in the rest of the story, this is about insider dealing. Okay? So David became very excited about the information he had heard about this new technology, and he immediately bought 5,000 shares in Phoenix after the board meeting. When he got home, he told his wife Maya about the project and strongly recommended she use all her savings to buy shares in Phoenix. He also asked Maya not to share this news with her friends on Facebook. The next day, Maya bought 2,000 shares. When Phoenix announced the success of its research project to the public in March, it received a lot of media coverage and global investor attention. As predicted, the share price went up by 20%. David and Maya sold the shares, made a huge profit. So I advise David and Maya of any criminal offense they may have committed, any possible defense may be available, and the penalties they may face. So insider dealing, as you may know, is from Learning Outcome 4. So according to the examiner, I think most candidates did very well. They were able to provide at least some information on the relevant concept, including the meaning of what is a connected person, what is inside information, and what is insider dealing. Only few were able to describe the possible defense, but you can see most did very well on the first part already. Okay, so how to break this down into smaller issues so it'll be more manageable to answer this type of question. So in this case, you can see there were two incidents in which David purchased shares and Maya purchased shares. So to decide whether they had committed insider dealing, an offense, I think it's better to look at them one at a time. So let's focus on David first. So which offense is possible or likely to have been committed by David? I think would be Section 291 of the SFO, Securities and Futures Ordinance. In particular, subsection 1, a person connected with a listed corporation and having information which you know is inside information in relation to a corporation shall not deal in the listed securities or counsel or procure another person to deal. So clearly, I think this one is relevant. That's why it's worth discussing. This one is also relevant, I believe, is a person connected with a listed company knowing that any information is inside information shall not disclose the information to another person, knowing or having reasonable cause to believe that other person will make use of information for the purpose of dealing. So these two offenses, I think, is possible. Now, in order to analyze this situation to decide whether they have breached these sections or not, we need some definition. What do you mean by inside information? So that's defined in Section 285. It can be specific information about the company, about a shareholder, about officer of the company, or the listed securities. Okay, so information about any one of them can already satisfy the first part of the definition of inside information. Okay, so what type of information are we talking about? It's information that is not generally known to the persons who are accustomed or would be likely to deal in securities, but would, if generally known to them, be likely to materially affect the price of the listed securities. So that's how inside information is defined in the SFO. Is specific information about the company, shareholder, officer, or the securities itself. It is not yet generally known to the public, but once known, likely to materially affect the price of those shares. So connected person, what does that mean? Well, there's a long list of parties or entities that can be connected with a company as explained in Section 287 of the SFO. And you can see in subsection 1A is if you're a director of the company or employee of the company, or part B, if you're a substantial shareholder of a company, you're already a connected person for the purpose of insider dealing offense. So what will be the likely penalties? So Section 303 is a person who commits an offense under this part is liable on conviction on indictment to a fine of 10 million and to imprisonment for up to 10 years. So you can see very high fine and also very high possible prison sentence for obvious reasons because they see this as a serious situation of insider dealing, and if it amounts to a criminal offense will be these sections. Okay, so you may recall I mentioned last time in part 1 of the online workshop, there are different sections. There are sections for criminal offense for insider dealing. There are also sections for civil offense for insider dealing. So the sections number, of course, is not the same. And for the civil one, you will appear before the MMT, the Market Misconduct Tribunal. And so the fines is not as high, and there's generally no imprisonment situation unless there's some situation where you go against the order of the tribunal. Otherwise, generally there isn't. So that's the main difference. So if you see a question of insider dealing, if this time it's not talk about criminal, talk about civil, is different section numbers, but the content, especially for the insider dealing part, is almost identical. So you do not need to worry. You can still answer the question in the same way. The biggest difference is the penalties. Okay, the penalties for the Market Misconduct Tribunal, they will not issue a fine of up to 10 million and will not be imprisonment for up to 10 years. Both the court and the MMT can hand down the orders. Okay, so recall, I think I might have mentioned, if not, it is okay. You can look at the study materials. Very common if you're a director of a listed company, you may receive a disqualification order. If you are a member of a professional body, let's say you're a lawyer, a CPA, or a company secretary, then there may be a disciplinary referral order where they inform your professional body and they will hold a hearing to decide whether your professional membership or qualification should be suspended or something serious. Also a disgorgement order. So if you made some profit from insider dealing, most likely you have to give those money back. And there's also cost orders, for example, SFC cost order or government cost order. So the cost of investigating you and prosecuting you, the judge, if so decided, or the chairman of the tribunal so decide, you may have to pay those back as well. So you can see just different type of consequences, but more importantly is no matter it's criminal or civil, at least the insider offense details of those sections, the wordings are almost the same. They're not exactly the same, but they mean around the same thing. Okay, so let's move on. Application. We now have all the relevant rules we can apply to our story to see what will happen to David. So in this case, David is a connected person. Why? Go back to the story, you can see he's the company secretary. So under the definition of connected person, if you're a director or employee of the company, you're connected. So here, David is employee of Phoenix Limited, so he's a connected person. Number two, is the information, would it amount to inside information? So the information about the new technology will be inside information as number one. It is not yet known to the public. Okay, at the time David bought the shares, the information is not yet known to the public, but if known, it would likely to materially affect the share price of Phoenix Limited. So in this case, in the facts already said, once released, it went up by 20%. So the case story makes it easier for you. It already moved into the future and told you factually the price went up. Okay, but the requirement of the section is likely to materially affect the price of the shares. In other words, if there's a good chance it would affect the price of the shares, that would already be enough to satisfy the definition of inside information. So apply all that to a relevant section, 2911A. When David bought 5,000 shares in Phoenix after the board meeting, since he's a connected person and he possessed inside information, that was insider dealing under that section. Okay, so that's offense number one. When he disclosed information to his wife, he has breached subsection 3 as he knew she would make use of information by shares. So the wife obviously knew her husband David works at the listed company and possessed the information of that. But more importantly is because David, he as an employee of a listed company, has a responsibility not to disclose the inside information. Okay, and there's a chance she would buy the shares. He even told her to buy the shares. So that's why the chance of him having breached 2913 is quite high as well. So if convicted on indictment, David may face fine of up to 10 million and imprisonment of up to 10 years. Okay, now what about Maya? Well, for Maya, I believe a different section number would apply to her. It will be subsection 5. The reason is because she is not a connected person. So just then we looked at subsection 1 and subsection 3 is talking about the connected person, David, committing insider dealing. But since Maya is not a connected person, that's why 1 and 3 would not apply to her, and instead subsection 5 would apply. So a person who has information, so it's a person, not a connected person, okay? Which he knows is inside information, which he received from a person whom he knows is connected with a corporation, whom he knows or believes held information as a result of being connected, shall not deal in the listed securities. So application. In this case, Maya, as David's wife, likely knew that David was a connected person and received information about the new technology because of his position in Phoenix Limited. So clearly she must know he's someone senior, maybe know he's the company secretary, and the information obviously she has not heard of before, the husband told her, so there's a high chance she already likely knew the information was inside information. So when she bought the 2,000 shares in Phoenix Limited on the next day, she committed insider dealing under Section 291, subsection 5. So if convicted on indictment, she may face fine of up to 10 million and imprisonment of up to 10 years. Okay, so I just finished going through the most recent exam paper, June 2024. Okay, so the idea, of course, hopefully, you can see is exam technique. Is reading through the question, the story. As you're reading the story, sometimes you can already guess the issues you need to discuss. For example, the quasi-partnership one was quite obvious, the insider dealing is quite obvious, the removal of director or the rights to the shares, all that I think is quite obvious. So as you're reading, you can already write one or two words on the side. Maybe that's the one being tested. So the reason why I asked you to write down on the side is because now that you're relaxed, watching the video is simple. You remember it. But in exam, when you're under time pressure, maybe under exam condition, feel more pressure, sometimes you may forget. So that's why by just writing down one or two words on the side, it helps you to remember. More importantly is if you need to refer back to the story, you do not need to read the whole story again. You just need to read that particular paragraph with the term next to it. So hopefully that's a small technique you might consider to help save you time and also help you remember. And then more importantly, of course, is after reading the question, by that time you should be very clear which issues you need to discuss. So for example, for a particular question, part A, there are two sub-issues, and then it's about director's duties, but it's director's duties about Owen, and then director's duties about Sophia and Lynn. And part B is talk about the removal of a director, and maybe talk about the expropriation clause. So after practicing a few times, it should not be that difficult, it should be quite manageable. That after reading the story and reading the question, you can already identify the relevant issues. So based on the examiner's comment, that is important, okay? So once you have done that, well done. You're already in the right track, you're heading in the right direction. Then based on your revision, you should already know, for that topic, I know to answer this question, these are the relevant rules I would need. Okay, so the relevant rules, of course, may be sections from the ordinance, maybe something from the articles, or maybe a court case. So those are the most common. And many of you have asked me in the past, it's a closed book exam. Does it matter if you cannot remember the section number? And I will say it's fair and reasonable. If you really cannot remember, but you remember the contents, remember the requirement. Okay, so if you're a connected person, you possess inside information, then you cannot deal with those securities. If you can write that down, but you forgot the number, I think it's okay. Or if you're a person, you receive some information directly or indirectly from a connected person, and then you knew the information he received was because of his position as a connected person, then I should not deal in the securities. Again, if you don't remember the number, but you remember the key criteria, the key terms, I think already very good. Same thing with court cases. If you can remember the name of the case, Ibrahimi and Westbourne Galleries, wonderful. If you really cannot remember the name of the case, but you can remember the story, okay, it was a quasi-partnership. They started off with mutual trust and confidence. They incorporated the business and they will manage it together. The relationship broke down. Now that person is excluded from management. So that will be grounds, will be just and equitable grounds to ask the court to wind up the company. So that would be the principle from that case. So if you do not remember the name, but you can write down the principle and apply that to the story to answer the question, also, I think that's very good as well. So just do your best. You find as you study, some case name, some section number, somehow you remember. So wonderful. You remember section 724, remember 725, wonderful. But if you really cannot remember, but you remember the content, remember the principle, the requirement, just do your best, write down what you know, apply what you know. Normally that's already very good. Okay, so if you're watching this video, I would suggest you can take a small break before we move on to the next exam paper in November 2023. For the November 2023 paper, let's start with the examiner's comment, the general part first. So you can see general performance candidates was relatively satisfactory. So this keyword I find sometimes is quite helpful because it gives you an idea overall the examiner's impression of the performance, general performance of the candidates. So June 2024, you can see is satisfactory, and November 2023 is relatively satisfactory. So I'm guessing they did better in June 2024. Now, for the part relating to section B, major problem was candidates' failure to correctly identify and address the relevant issue and rules. So you will note this comment is almost identical to the one for June 2024. So the biggest difference is, I guess, in the previous diet, they improved their answers for section A, but they seem to have the same problem or similar problem for section B. So many of the candidates simply describe rules and cases that were unrelated to the question, okay? Such as providing information about the rules regarding a breach of director's duties, even though this was not applicable to the question. So it's similar, but not exactly the same problem. June 2024, many just copy out the story and copy out the question. For November 2023, they try, some of the candidates try to explain some rules or cases, but they are not relevant to the question. Okay, so that's why I said it is important first to work out what are the main issues or sub-issues you need to discuss to answer that question. Once you have done that, higher chance the rules you use or explain will be more relevant to answering the question. So sometimes I see some students for company law, every question they think is director's duties. Okay, so I think that happened in November 2023. If I recall correctly, one of the questions really was about director's duties, but the other ones were not. But saw some candidates for all of those questions talked about director's duties. So as part of your exam technique and strategy, you have to think, would the examiner examine the same topic, question after question after question? Generally speaking, I would guess probably not. So if you find yourself using the same rules and talk about the same issues and topics for many questions in section B, there must be something wrong. So that's why take a bit more time, look at the relevant issues before you decide which of the rules is relevant. So candidates are reminded they can only achieve good results if they correctly identify most of the relevant issues to relate to each question, and they expect to demonstrate analytical skills. So I think that part is quite helpful because you're under an exam, under pressure with limited time. So I agree, sometimes it's not possible to answer everything perfectly 100%. But I think if you can correctly identify most of the issue, discuss most of the relevant rules and apply to the question to get your answer, I think already very good. Okay, because your aim for a professional exam, of course, is number one, you want to make sure you pass the paper first. It is wonderful if you get an even higher mark, but I think the minimum requirement normally is you want to pass the paper first. So that's why do not force yourself, do I need to try to think of 3 sub-issues for every question? I think probably not. Number one, you don't have the time, and not all questions have 3 sub-issues. Some only have 2, or some, I think most of them will have around 2. But it's possible you may have 1 or may have 3, depending on the question. So that's why just do your best. Read the story, read the question, and which of the issues you believe is more relevant, focus on them first, and always watch out for time. Okay, so let's look at the first question. We're Foster Limited. Dry cleaning company has 3 directors, Arja, Beth, and Kai. They have 20, 30, 40% of the shares of the company, respectively. Remy holds the remaining 10%. So you can see 3 of them are directors and shareholders, but Remy is shareholders only. So the company adopted the model articles with an additional clause that provides the directors will not be liable in connection with negligence, default, or breach of duty or trust. So this is quite a broad clause that seems to cover everything. Almost like no matter what the directors do, right or wrong, they will not be held responsible. So let's continue. So in April, Aja was in charge of purchasing a new brand of laundry detergent from an overseas supplier, placed an online order of 80,000 as he was in a rush to leave for a friend's birthday party. He did not check the ingredients carefully. When the detergent arrived, it was discovered it did not meet the legal safety requirements in Hong Kong, and all of it had to be thrown away. So you can see here is an example where a director entering a transaction for the company did not check carefully, and turns out the goods delivered cannot be used safely in Hong Kong. Then in May, Foster Limited, the company, was approached by Joe, a director of Perfect Clean. Joe offered to sell the latest model of dry cleaning machines to the company at a very competitive price. So at the board's meeting, Beth said that the latest model was more energy efficient than the current machines. Kai had concerns about the reliability of the new machines, but she kept silent. The board finally decided not to go ahead with the purchase due to recent market uncertainties. Shortly afterwards, Beth secretly set up her own laundry business, B Clean Limited, and purchased machines from Perfect Clean. B Clean later sold the machine and made a profit of 100,000. So this seems like a director having information and being able to use it to make some extra profit. So Remy is unhappy. So remember, Remy is the shareholder with 10%, unhappy with the director's action, and he's considering bringing a claim against them to recover the losses suffered by Foster. So provide advice on whether the directors of Foster's are in breach of the director's duties and what legal claim Remy could bring against the directors, explain the process of this claim and what factors the court would take into account. So it's quite interesting because I think the question, the way it is written, is very clear, also quite precise. So to the point, when you need to work out which issues to discuss, I think after reading the questions, you should have no doubt. So let's look at the examiner's comments. Before we do that, the topics. So breach of director's duties, members' remedies, they're from Learning Outcome 2 and Learning Outcome 3. So according to the examiner, most correctly referred to the relevant rules and concepts for breach of director's duties. Most also demonstrate an understanding of the concepts and procedures for the statutory derivative action. However, some candidates confuse the concept of statutory derivative action with an unfair prejudice remedy. So candidates are reminded you need to distinguish between a derivative action and a personal action. So we covered unfair prejudice remedies in the June 2024 exam paper just then. So you can see that is governed by a different section than that for statutory derivative claim. So obviously you would expect the requirement will not be the same. So for the final sentence is saying candidates need to understand the difference between the two. Well, derivative action, what does that mean? That's basically meaning an action you go to court on behalf of the company. Okay, there's something done wrong, for example, by a director. So derivative action is you are not a director, but you apply to a court because the directors have done something wrong. So usually if the company wants to take an action, it will do it itself and it will be done, it will be launched by the directors. But if the directors are the one doing something wrong, you will be surprised if they would launch an action on behalf of the company against themselves. So that's why it's called derivative action. Personal action is where you launch an action for yourself. For example, like the unfair prejudice claim under section 724, 725, you're asking the court for help for yourself. So for example, if the court issues a buyout order, it is to buy the shares from you. So you get a fair price for your shares. So you can see the difference. Derivative action, you're doing something on behalf of the company. So if the court hand down some relief, it will be for the company, not for you. Whereas a personal action is you feel something is done against you and you ask for remedy, you ask the court to do something to help you and maybe give you some relief. Okay, so the first one is article exempting directors from liability. So you recall in the story, it shows the content of the clause, additional clause in the article of the company. It's basically saying no matter what the directors did wrong, they will not be held liable. So let's start with section 465 of the company's ordinance. So this section applies to the provisions contained in the company's articles. Subsection 2 is if a provision purports to exempt a director of the company from any liability that would otherwise attach to a director in connection with any negligence, default, breach of duty, or breach of trust in relation to the company, the provision is void. So you can see is the legislation already cover this area, already foresee this possibility, is if you add a clause in your articles trying to relieve the directors from any liability or responsibility, even though they were acting negligently, they were in default, they breached their duty as a director or breach of trust, then of course the provision cannot work. So that's why the provision is void, meaning even though it's written in the company's articles, it will not be counted as a valid clause and will not be enforced by the court. In other words, will not protect the directors. Okay, application. So in this case, the company's article stated directors will not be liable in connection with negligence, default, or breach of trust, breach of duty or trust. So applying 468, the above provision is void and will not exempt directors from liability due to negligence, default, breach of trust, or breach of duty. Okay, the next sub-issue for question 7 would be the breach of director's duties in relation to the purchase of the laundry detergent. So you'll recall Aja was in a rush to go to a friend's birthday party and ordered the detergent that's not suitable for use in Hong Kong. So the relevant sections, we've seen this before earlier on, is section 465 of the company's ordinance. A director of a company must exercise reasonable care, skill, and diligence. And how do you decide what level of care, skill, and diligence is that which will be exercised by a reasonably diligent person, a reasonable, careful person, and it will be based on the objective test that you would expect of someone holding that position of a director of that company, and the subjective test is the actual knowledge, skill, and experience of that particular director. So the subjective test, I believe, will only be relevant if that director has higher knowledge, higher skill, or high experience. Okay, if the director in question do not possess higher knowledge, skills, or experience, you just use the objective test in part A, and that will be sufficient. Okay, so application. So in this case, Aja was in charge of purchasing a new brand of laundry detergent from an overseas supplier. So you're buying something on behalf of the company from an overseas supplier, so it's not from a local supplier that you're used to dealing with, and they may come from different jurisdiction, different laws, and of course, possibly different laws on safety. So a reasonably diligent person with general knowledge, skill, and experience, so that's the objective test, that may reasonably be expected of a person carrying out that function would have checked to ensure that the detergent could be used in Hong Kong. So you run a dry cleaning business. It's part of your business to accept clothing items from customers and you'll wash it for them. So obviously the detergent you buy must be safe enough for you to use in Hong Kong. Since Aja did not check carefully, the detergent could not be used and the company had to bear the loss. So it's likely that Aja had breached the duty of reasonable care, skill, and diligence under section 465 of the company's ordinance. Okay, so what about Beth in terms of the dry cleaning machines? So can look at Cook and Deeks. We covered this briefly before. Duty not to usurp corporate opportunity, not to steal opportunity you got from the company. So men who assume the complete control of a company's business must remember that they are not at liberty to sacrifice the interests which they are bound to protect, and which ostensibly acting for the company divert in their own favor business which should probably belong to the company they represent. So directors are acting for the company and should be in the interest of the company. So if there are opportunities available, existing, obviously you should let your company benefit from them rather than divert those opportunities in favor of your own company so that you yourself will benefit. There's also the famous IDC and Cooley case, Industrial Development Consultants case. A director who resigned and took up a contract that was negotiated by a company was held to have breached the director's duty not to usurp corporate opportunities. So the information about the opportunity was obtained while he was in the position of managing director of the company, so he must account for the fees of the company. So you can see is because you are director of the company, that's the reason why you were able to contact the other party. That's why you got the information. That's why you got the opportunity. The opportunity only arose, only became available to you because of your position in that company. So since that corporate opportunity belongs to the company, of course, you should not usurp, should not take or steal the opportunity away from a company for your own benefit. So in that case, we'll have to account for the fees back to the company. So application. So in this case, Beth was able to purchase the dry cleaning machine at a competitive price because of her position as a director of a company. If she wasn't a director, she would not even have heard or may not even have heard about the company or the dry cleaning machine or the price. So based on Cook and Dees, the opportunity belonged to the company and Beth should not usurp the opportunity for her own benefit. So although the company decided not to purchase the machines, based on IDC and Cooley, Beth still need to disclose to the company before taking advantage of the opportunity. So Beth cannot argue, didn't you just have a meeting and did you not just turn down that opportunity? That's one thing. That's for the company. But since you received that information and that opportunity because of your position in the company, the right thing to do as part of your director's duty is to disclose to the company, since you do not want it, I want it for my company. Is that okay? So if she asked and they said, okay, we don't mind, everything will be fine. There will be no breach of director's duty in this respect. Okay, then we move on to the next issue, is talking about, okay, how can you claim the members' remedy? So we have the statutory derivative action. So as I mentioned, this is something you want to take up on behalf of the company. So under 732, if misconduct is committed against a company, a member of the company may, with leave of the court granted under 733, bring proceedings in respect of the misconduct before the court on behalf of the company. Okay, so as I mentioned before, if there's anything done against a company, of course it is the company that should go to court to ask the court for help. Now, but if in some situation where it is decided the misconduct is done by the directors, it will be difficult or unlikely for the directors to go to court to bring a claim against themselves. So that's why under 732, it is possible for a member, okay, to basically bring proceedings on behalf of the company. So 732 basically addressed the proper plaintiff rule because the proper plaintiff in this situation should have been the company. But because of this situation, legislation under section 732 basically provides the exceptions, allow a member, the shareholder of the company, to bring the action on behalf of the company. Okay, so in order to invoke 7321, there must be a misconduct. So is misconduct defined? Well, it's defined in section 731. It means fraud, negligence, breach of duty, or default in compliance with any ordinance or rule of law. So if you fall into any one of those categories, then it's possible you may have satisfied the requirement of misconduct in order to bring this claim if that's what you want to do. So what happens if the court consider your case? What can the court do? So the court may grant leave if it is satisfied that on the face of the application, it appears to be in the company's interest that leave be granted to the member. So of course, the judge still wants to find out what is this about? What is the problem? What are you claiming against? And if it turns out there is a prima facie case based on information provided and it's in the interest of the company to allow the member to bring forward the case on behalf of the company, then generally the court will grant leave for the member to do so. So in the case of an application for leave to bring proceedings, there's a serious question to be tried and the company has not itself brought the proceedings. So cannot be a minor matter, must be a serious question that needs to be decided by the court. And more importantly, the company has not itself brought the proceedings. So this section is for a member to bring proceedings on behalf of the company. If the company is already doing that, of course, there's no need for the member to bring the proceedings on behalf of the company. Otherwise, you have a duplication, okay? So, application. In this case, Remy, as a member of a company, may consider to bring a statutory derivative claim against the directors of the company under Section 732. So if Archer and Beth have breached their duties as a director, that would amount to misconduct under Section 731. Then, under 7331, the court may grant leave if it is satisfied that it would be in interest of the company to do so, as the company may have incurred losses or missed out on business opportunities due to their misconduct. It may be in the company's interest to pursue a claim against them. We also need to show that there's a serious question to be tried and the company itself had not commenced proceeding itself. So if that's the case, then you also need to serve notice on the company. So you need to inform the company a member has brought a claim on behalf of the company. So it knows it's actually now part of court proceedings. Okay, so now let's look at question number 8. Ray Limited owns and operates various water parks across the region. The company was incorporated in 2015 with issued share capital of 90,000 divided into 50,000 ordinary shares at $1 and 40,000 preference shares also at $1. So we've seen a question similar to this in the June 2024 situation, is where you have two classes of shares. You have ordinary shares and preference shares. Now the company has 3 directors, Amal, Cora, and Ying. So the article states that the holder of preference shares are entitled to 3% preferential dividend and they have a right of priority in repayment of capital and to vote at class meetings. Articles are silent on how the rights of preference shareholders are to be varied. So useful information there, okay? It's talk about the rights of the preference shareholders. So in 2018, the directors were considering building another water park and the board agreed to purchase a piece of land from Oscar Land Limited for $500,000. So unknown to Amal and Ying, Cora's husband, Oscar, is the only director and shareholder of Oscar Limited. So we have another transaction decided by the board of directors in which one of the directors, it would appear, is somehow connected to the party that will be actually selling the land to the company. In 2021, Ray Limited's business was struggling due to COVID. The board member felt the preference shares were a burden on company's resource to propose reducing the preference dividend from 3% to 2%. Sammy, who owns 20% of the preference shares, is not happy with the proposal. So you can guess, hopefully by now, since we have more than one class of shares, and it looks like they're trying to reduce the percentage payable as preference dividend to the preference shareholders, and understandably, Sammy, the preference shareholder, is not happy about it. So clearly the matter about varying the rights and getting the consent that we looked at earlier would be relevant here. So I would definitely put down varying rights of a class of shareholders. Now, the company has not been making a profit for the last 3 years. So in order to improve the company's reputation, the board recommends a dividend of 50 cents per share is paid. Dividend is declared and paid. So this is talk about payment of dividend. So advise the board in relation to validity of following transactions. So we have the one where they bought the land. The second issue is reducing preferred dividend. And the third one is on the payment of dividend. Okay, so let's first see the topics, declaration of interest in contracts, variation of class rights, payment of dividends. That would be from Learning Outcome 2 and Learning Outcome 4. So in the examiner's comments, you can see most candidates correctly explain and the procedures for variation of class right, but only a few managed to point out that the 10% of shareholders in relevant class may apply to the call to objective variation. So that's if you disagree, what can you do? And also many candidates simply explain the concept of fiduciary duties of a director. So here's an example where despite finished discussing about director's duties in question 7, some students still spend time discussing director's duties in question 8. So just be careful. Is it possible some topic may appear in more than one question? Of course, but I think it will be unlikely to appear in many questions over and over again. So make sure, I think in this one, you look at the question, it's already quite helpful. Because remember in question 7, the examiner clearly asked the candidates to discuss director's duties. But in question 8, it said the transaction between these and the preferential dividend and payment dividend. That's why more likely director's duties is relevant to question 7, but not as relevant comparatively because there are more specific issues you can discuss for question 8. So most correctly noted, dividends have declared of distributable profits. So that's good. So that's important for answering the final sub-issue. So let's first look at the first issue on the purchase of land from Oscar Limited. So we've seen this before, Section 536. If a director interested in a transaction with the company that is significant to the business and the director's interest material, director must declare the nature and extent of the interest to the other directors. So that's why if you are a director, you must inform other members on the board of directors about your interests. And declaration in interest must be made as soon as reasonably practicable for obvious reasons. If you're negotiating and about to sign a contract for the company, and it turns out one of the directors has an interest in the transaction, of course, should inform the board as soon as reasonably practicable. And generally should be before the company enters into the transaction. Because once you enter into the transaction, that means you already signed and concluded the contract is binding. So that's why it's important to declare, to disclose your interest, but also do it as soon as reasonably practicable, and also do it before the company concludes the transaction. And the procedures is a declaration made at the directors meeting by notice in writing or by general notice by a director. So there are different ways you can do it, but most important, you must inform the board members of board of directors. And here, duty of directors to declare an interest apply to shadow directors the same. So you may recall I explained about directors and shadow directors. Directors, generally speaking, is the de jure directors, the directors who are officially appointed. Shadow directors are not officially appointed directors. They do not sit on the board, but in most cases, they are likely to control one or more members on the board of directors. And so it's the shadow director acting behind the scene, pulling the strings, who is actually making the decisions, rather than the actual people who are actually sitting on the board. Okay, application. So in this case, under Section 536, Cora should have disclosed her interest in the transaction since her husband was the only director and shareholder of Oscar Land Limited. So you can see this is clearly quite significant because it's not like you own 1% shares in a company that is doing a deal with your company. It's basically your spouse owning all the shares and is the sole director of the company. So that's why I really should have made the declaration before the company enters into a transaction or as soon as reasonably practicable. So otherwise, she would commit an offense, and as we saw last time, fine is at level 6, which is very high. At the moment, I believe is $100,000. So she may also breach her duty as a director to avoid conflict of interest, because if she's helping to negotiate a contract on behalf of the company or making a decision, and it turns out she, in an indirect way, would gain from the transaction, So when they're negotiating, is she having the interest of the company in her mind or having the interest of her husband's company in her mind? We don't know. So that's a conflict of interest which should be avoided by declaring to the other members of the board. Okay, then we move on to the second sub-issue is the reduction of the preferential dividend. So would this amount to a variation of class rights? So if we look at the first case, it's saying there is, to my mind, a distinction, a sensible distinction between an affecting of the rights and an affecting of the enjoyment of the rights. So you need to be clear which one it is in order to decide whether it amount to a variation of class rights. In the second case, a reduction of capital on all shares is not an alteration of rights of the preference shareholders so as to require their consent. So we had a similar situation in a June 2024 question paper, and we've dealt with that already. So let's look at this situation. And then we have section 180. We've seen this before in the previous paper, is if it amounts to a variation of class rights, then you will need to basically follow section 180, depending on whether you have a provision on variation of rights in your articles. If not, then you jump to section 183, which is you need written consent by 75% of the shareholders of that class, or you need a special resolution of the preference shareholders in that class meeting. And then under section 182 is if the rights attached to the shares are varied, holders representing at least 10% of voting rights may apply to the court to have variation disallowed. So this is if they manage to get enough votes to get the consents in order to vary the rights, and you as one of the class holder do not agree, then if you have sufficient shares or votes, then you can apply to the court for help. Basically, that's what 182 is about. However, holder may not apply to the court if the variation is made with the written consent of all holders or resolution passed unanimously. It's basically saying you cannot change your mind. What does that mean? It means if you voted to consent to a variation, at the time of voting you said yes, then you cannot now change your mind and go to the court and say, I want to object. Because when you made the vote to agree or not to agree, to consent or not consent to a variation, you should make that decision carefully. So if you already said yes, you cannot go back to the court and say, I want to say no now, okay? So the court may, by order, disallow the variation if it's satisfied that the variation would unfairly prejudice the member represented by the applicant. If the court is not so satisfied, it must by order confirm the variation. So even though the matter may go before the court, it does not mean the decision will be reversed. It's entirely possible for the court to say, this is not right, it's unfairly prejudiced, so I would disallow the variation. So whatever change they made to articles, it would not be valid. However, it's possible for the court to say, everything is actually okay, it's fine. So the court can actually confirm the variation, then it will be a valid clause and it will be enforced. So application, we now have all the relevant rules we can now apply to our story. So in this case, reducing the preferential dividends would amount to a variation of rights of the preference shareholders, because clearly they sign on the right for 3% preferential dividends. You now want to reduce it from 3% to 2%. So since the articles is silent on the rights of preference shareholders, what you need to do if you want to vary those rights, you need to refer to the relevant sections in the company's ordinance. So in that case, you will need written consent representing at least 75% of the voting right, or pass a special resolution in a separate class meeting. So in this case, Sammy owns 20% of the preference shares. Okay, so if Sammy is the only preference shareholders that disagree with the variation, then it would not have enough vote to stop the consent of 75%, okay? Because she will need more than 25% to basically block the 75% written consent or the special resolution at a separate class meeting. So in that case, it will go ahead, but What else can SEMI do? Well, because SEMI held more than 10% of the preference shares, it's also possible to apply to the court under Section 182 to disallow the variation. So based on subsection 5, you need to show the court that the variation would unfairly prejudice the preference shareholders. If you succeed, then the variation will be disallowed. But if not able to succeed or cannot convince the court, then the court will simply confirm the variation under subsection 6. So as the change would also amount to an alteration of articles, will require a special resolution under Section 88(2). So don't forget, we're still trying to alter the articles. We're amending the contents of the articles. So you still need to refer to Section 88(2), where you need special resolution by the shareholders in general meeting. But based on the story, it's likely they would have enough votes to pass the special resolution. If SEMI want to challenge the alteration, you can challenge under Allen and Gold Reeves, which basically say that when they exercise the power to alter articles, it must be done bona fide for the benefit of the company as a whole. So it will depend on the argument, but it's possible it's for the benefit of the company, especially if the company can no longer afford to pay such a high, or in that situation, a high preferential dividend. Okay, now to the third sub-issue is about the payment of dividend. We'll start with Section 297 of the Companies Ordinance. So a company may only make a distribution out of profits available for distribution. So for this purpose, a company's profits available for distribution are its accumulated realized profits less its accumulated realized losses. So it's the excess amount on top that you were able to earn from your business of the company. That excess amount, the sharing of the profit, you can use to distribute as dividend to your shareholders. So consequence, what happens if you do not follow the requirement? Well, this section will apply if a company makes a distribution in contravention of the section we looked at, and at the time the member knows or has reasonable grounds for believing this distribution is made in contravention of that section. So if you know or you have reasonable grounds to believe when they pay the dividend, it's actually not just out of profit, then of course will fall foul of this section. If the distribution is made in cash, the member is liable to repay the distribution. So once they pay the dividend to the shareholders, it's possible to get the money back from them. And if it's made in other ways, then it's possible to get the distribution back from them in assets otherwise than in cash. Okay, so look at some court case. So if the directors were aware that the company did not have distributable profits and there were irregularities in the financial statement, that will be a breach of duty and will be liable for dividends wrongly paid out by the company. So remember, it's usually the directors that would declare the payment of dividends. Directors usually they're in the best position to know the financial position of a company, whether the money paid out as dividends is out of distributable profits or not. So if the directors knowingly pay out dividends even though it's not from distributable profits, or if there's irregularities in financial statement, number one, there will be a breach of director's duty, and number two, of course, is the directors may be liable for the dividends. So the money must come back. It's either from the shareholders, but if you cannot get it all back from the shareholders, then you can actually get from the directors if it falls into this situation. If the director was negligent and allowed dividends to be paid not out of profit, director can be held liable for the payment. So you can see they can actually go after the directors. Okay, application. So in this case, since the company has not made a profit for 3 years, there is a chance that the accumulated loss may exceed the accumulated profits of the company. Okay, it's not certain because I cannot see the financial statement. Okay, but at least based on the limited information, there is a chance. In that case, the payment of dividend may have breached Section 2971. It may not have been from distributable profits. The members would therefore be required to repay dividends back to the company under 3012. If the directors were aware that the company did not have distributable profits, then based on the court case, it's possible to claim on the directors, even though the dividends were paid to shareholders. So this is an interesting point, Because even though the directors might have done something wrong, might have declared the payment of dividends that is not out of distributable profits, even if the directors themselves did not receive the money, it is still possible to claim against the directors for those money because the directors were in a responsible position and they should have made sure that did not happen in the first place. Okay, we now look at question number 9. Turner Limited is a computer software company incorporated in 2015, has 2 directors, Rose and Ahmed. Turner Limited was hit with rising costs of running business. In July, it became unable to repay its debts. It was placed in compulsory liquidation in September 2022. So a liquidator was appointed. He collected all of Turner's assets, selling them for 1.5 million. He discovered the following 2 charges, which were both validly registered. So I think by the time you finish reading the first 2 paragraphs, you can already, should be able to guess what this is about. Clearly, this is talking about a liquidation, compulsory liquidation. That means it is liquidation, I guess, wound up by the courts. So, and the court appointed a liquidator. You can see the company is insolvent because in July 2022, it became unable to pay its debt. So insolvent, liquidation, assets of 1.5 million. There were 2 charges validly registered. So you do not need to spend a little bit of time talking about whether they're valid registered or not. It's already stated in the facts. Okay, so let's continue on the 3rd paragraph. Back then in April 2018. So the liquidation started in 2022. We're now looking at about 2018. So we're looking backwards in the past. Turner obtained an overdraft from Dora Bank for 400,000 and a charge was created over all its book debts arising from its ordinary business. The charge document states the overdraft is secured by a fixed charge and Turner must pay the proceeds from his book debts into the designated bank account with Dora Bank. Turner, however, is free to draw on the account for his business purpose, provided that the overdraft limit is not exceeded. So the 3rd paragraph is already very similar to one of the court case. I think you may know from your review, your revision, and it's talking about whether it is a fixed charge or a floating charge. Then moving on now, August 2022. This is just a short time before the liquidation commenced, I guess. Turner obtained a loan of 300,000 from Thai Bank and a floating charge was created over its entire undertaking to secure the loan. So we can see here there may have been some overlap in the assets that has been used as security for loan. Then we have the liquidation expense of 42,000, unpaid tax of 100,000, 10 employees claiming 6 weeks unpaid wage of 80,000 each, and Turner also has 1 outstanding unsecured debt of 80,000. So you can see there are enough information about the liquidation, about the charge, what happened before. You know the assets, you also know the liabilities. The amount needs to be paid. So obviously, the most important thing, of course, is the priority, the ranking, because in an insolvent liquidation, whether you get paid first or second or third or fourth, it does matter. Because if there's not enough money to repay everyone in full, the earlier you get repaid, the better, the higher chance you get something. So the questions, again, I can see very clearly stated here. Discuss the nature of the charge created over the book debts in favor of Dora Bank. So this is the one where I talked about in the 3rd paragraph. Is it a fixed charge or floating charge? Discuss whether the floating charge created in favor of Thai Bank is valid. So we have the 4th paragraph, the 300,000 loan, and then explain the order of distribution of Turner's assets. So you already know there's only $1.5 million remaining. So who gets paid first, you minus how much, and you work down the line one by one to see who gets paid and who, I guess, will not get paid. So the nature of charge and validity of charge and order distribution, all these are from Learning Outcomes 4 and 5. So here you can see, according to the examiner, I guess everyone did well. You can see able to explain about the charges, about control, about the invalidating the floating charge under 267, and the order distribution. This looks like a good question for that year for the candidates. So let's look at the issues one at a time, starting with the charge over the book debts. And the court case, hopefully you already have in mind, is the ReSpectrum Plus case. A charge expressly stated as a fixed charge, but its characteristics of a floating charge likely to be treated as a floating charge and not have priority over preferential creditors. Okay, so this case is saying, is it a fixed charge or is it a floating charge? It is saying it will not just look at the labels. Just because they wrote down in the document, this is a fixed charge. If in substance, if the characteristics, the way they do things, do not reflect a fixed charge, then the answer is no. It will not be recognized by the court and the liquidator as a fixed charge. And if it's treated as a floating charge instead, then the priority will be quite different. Fixed charge usually come first in the priority, usually, whereas floating charge has a lower priority. Okay, floating charge is after preferential creditors. So what are the characteristics of a floating charge? We can look at the second court case. Its charge is taken over a class of assets. The class of assets change constantly, and the company that borrowed the money that granted the charge is free to deal with and use those assets. So imagine if I granted a floating charge over the inventories, then during the term of that charge, before it crystallizes, I'm free to deal with those inventories. I can buy more inventories, I can sell inventories and use the money to buy more inventories. That's typical arrangement of a floating charge. Okay, application. To apply to our situation, the company granted a fixed charge over its book debts to secure an overdraft of $400,000. As stated in a charge document, although the proceeds from the book debt must be paid into a designated bank account, the company is actually free to draw on the account for business purposes, as long as you do not exceed the limit. So you can see there's no restriction, and the control is actually still with the company. The company can draw the money out as it requires for its business. So based on the second case, Yorkshire WooCommerce, it would appear that the charge that was actually granted in this story has the characteristic of a floating charge instead of a fixed charge. So similar to a ReSpectrum case, the mere labeling the charge as a fixed charge would not be sufficient, so it's likely the court would treat the charge as a floating charge instead. Okay, what about the second one? Validity of floating charge grant to Thai Bank for the 300,000 loan. So since it's a floating charge, and I mentioned it happened not long before the start of the liquidation, most likely Section 267 will be relevant. So there are a number of sections the liquidator can use, but 267 is specifically for floating charge. So anytime you see a questionable floating charge, it will be good to start with this one first. So if the company creates a floating charge on its undertaking or property at a relevant time, the charge is invalid except to extend the amount in subsection 3. So 267 is very simple. If a floating charge was created during the relevant time, it is not valid, full stop. Okay, that's the general principle under subsection 2 of 267. Very easy. Okay, there's only one exception, is even if it was granted during the relevant time, if it satisfies the exception in subsection 3, then it is still possible the charge is valid. It will not be invalid. Okay, so before we look at subsection 3, I think it's important to look at relevant time. So what does it mean by relevant time? So under 267A, if it's a floating charge granted in favor of a person other than a person connected with the company, then it is as follows: 12 months and also unable to pay its debts. So if it is a connected person, the relevant time will be 2 years. In this case, it's not a connected person. So in order for the charge to be granted within relevant time, number one, it must be done 12 months from the commencement of winding up. So if commencement of winding up is today, you count back 12 months. And if the floating charge was granted during that period of time, it is possibly a relevant time. Since it's a non-connected person, if during that time when you granted a charge, it either your company was unable to pay its debts or because of the transaction caused your company to be unable to pay its debts, then yes, it will be relevant time. In that case, the floating charge will be invalid unless you can satisfy the exception in subsection 3. And what is this about? The money is the aggregate of the value of so much of consideration for the creation of the charge that consists of money paid to the company. What is it talking about? Well, it's just talking about a normal commercial transaction. Because despite these sections, you still want to protect the normal commercial transaction. So normally in business, when would you grant a floating charge? Very simple. When the bank or the lender offers me a loan of money, that's the proper and that's the normal commercial transaction. So that's why subsection 3 is known as the new money exception. If there's new money that is given to the company or lent to the company in return for granting the charge, it is okay. But if you look at the entire transaction, no matter how complicated it turns out, no new money was granted to the company, but you gave the charge to the lender anyway, then there's something wrong because you're actually affecting the priority when a company goes into liquidation. So that's the reason why they have subsection 3. So if floating charge created within the relevant time is invalid unless it is satisfied the new money exception. For company that is not connected, in addition to the 12 months, you also need to show the company was unable to pay its debts at the time. So application, let's apply that to our story. So in this case, the company became unable to pay its debts in July 2022 and was placed in compulsory liquidation in September 2022. So it's likely the commencement occurs sometime between those two dates. Therefore, the floating charge granted to Thai Bank fell within the 12 months because it was granted in August. So the requirement that the company was unable to pay its debts likely to be satisfied because it says the company was unable to pay its debts in July. So however, if the loan fell of 300,000 fell within the exception of the new money, it is possible the floating charge can still be valid. So despite the first paragraph, if it can be shown the 300,000 to the company is a new loan, then it will still be okay, at least from the perspective of section 267. Okay, order of distribution. So this is just a general summary. So obviously it's not detailed, not exhaustive, but generally, as you can see, fixed charge will come first, liquidators amounts will come next. Then you have preferential creditors under section 265. Then you have floating charge. Then you have unsecured creditors. Then you have shareholders. Okay, so that's why just then in the ReSpectrum case, was saying that if it was a fixed charge, it will come before preferential creditors. But it was decided it was not a fixed charge, it was instead a floating charge, it will come after preferential creditors. Now, in an insolvent liquidation where there's not enough money to repay all the creditors in full, by the time you distribute to unsecured creditors, that will be it. They will get a partial payment and you run out of money. Okay, so the shareholders will never get anything. But if there was enough money to repay all the creditors, then of course the excess, the surplus, will be returned to the shareholders pari passu based on the shareholdings. Okay, so what about the liquidation expenses? So under section 1791, assets of a company winding up by the court remaining after payment of fees and expenses in preserving, realizing, or getting in the assets, and then will be then subject to any order of the court be liable to the following payments which have been made in the following order of priority. So first of all, the official receiver will be paid, then the necessary disbursement of any liquidator. So therefore, the liquidator's expense, as you can see, will have quite a high priority, comparatively speaking. So most likely the 42,000 can be claimed. Okay, so what about the preferential creditors? So Section 2651 of Cap 32 is actually a very long section. It covers many different categories that will fall under preferential creditors. So I just took some out, highlighted some just for information so you can see. For example, for employees, for the salary and wages, then up to the first $8,000 for each employee that would have a higher ranking as preferential creditors. The remaining ones, of course, will not be preferential creditors. Payment in lieu of notice, maximum $2,000 per employee, and non-service leave payment, maximum $8,000 per employee. There's also other statutory debts within 12 months, for example, tax payment outstanding that should be paid to the Inland Revenue Department that will also be categorized as preferential creditors as well. So in terms of application, apply to our story. You can see it says there are unpaid wages of 80,000 for, so you can see for there are 10 employees, so the maximum is 8,000, okay? So what it's saying is the first 8,000 for each employee will be ranked as preferential creditors. So if there are 10 employees, so the first 80,000 of the full amount owed to employees will be treated as preferential creditors, and the remain, of course, will be treated as unsecured creditors. So there is a protection of wage under insolvency fund, but that's something separate. But for the purpose of ranking on liquidation, and if it falls under preferential creditors, it will be the first 8,000 per employee. Then the unpaid tax bill of the 100,000 also treated as preferential debts as well. Okay, so you can see these are the different amounts. You add them all up and see when you can settle the 1.5 million in assets. Okay, so we have now finished the exam paper for November 2023. So just like before, if you want, you can take a break before you continue watching. We will now move on to the exam paper for June 2023, the next one. Okay, so let's look at the examiner's report for the general one for that year. So you can see here the keyword satisfactory. So overall, it was okay. But then it talked about some candidates still demonstrate a weak answering technique, particularly in the elective questions in section B. The major problem for most candidates in section B appeared to be their failure to correctly identify and address the relevant issues and explain the relevant rules. So you can see it's the same comment 3 times in a row. And I think this is important because section B, the questions, 3 of them, 25 marks each, is worth 75% of the paper. So clearly can see you must do well in section B if you want to pass the paper. Because even if you get perfect score in section A, you only get 25 marks. And no one aims for a perfect score in an exam. It's actually not possible because you have limited time, you have pressure. So that's why I think if you can, if the candidates can improve on section B, then naturally they will perform better for the paper overall. So that is important. So many candidates just describe various rules and cases that were irrelevant to the question. So you can see this one is almost the same as the comment for November 2023. Is you look at the issue carefully and then decide which of the rules and cases relevant to the question. Otherwise, it's very easy to end up writing a lot about many rules, many cases. That's not relevant to the question, then it'll be very difficult to score any marks at all. Okay, so candidates are reminded to achieve a good results, they need to correctly identify most of relevant issues and also demonstrate analytical skills. So that should remain the same for section B. Now, let's look at question number 6. We have Rob and Dom have run a successful health food business in partnership for many years. In 2020, they decided to incorporate the business. The company Camellia Health Limited was formed. Camellia has an issued share capital of 600,000, comprised of 500,000 ordinary shares and 100,000 preference shares. So again, we have a situation of more than one class of shares. All the shares are fully paid. However, the company has been struggling financially since it was incorporated. It has few assets and rather a debt of over 500,000, with Zebra Limited one of its largest suppliers. So possible solvency issue. Camelia's Health Limited article states the holder of preference shares are entitled to a 10% fixed dividend and preferential repayment of capital on the winding up of the company. So Liz has recently joined Camelia's board as a director, has expressed concern about the company's financial situation. She is unhappy with the preference shares arrangement. She suggests the director should cancel preference shares, pay off the preference shareholders. If that is not possible, should reduce the percentage to 5%. Rob and Dom agree. May, who holds 25,000 preference shares, learns of the plan and warns them that she will not approve. So this is quite similar to what we saw earlier. So we have these, looked at these topics before, and according to the examiner, most candidates fail to identify the issue of a reduction of capital, but some of them discuss variation of class rights. So one sub-issue they did not cover, but the other issue they cover. So it's good. At least they were able to answer part of the question. That is very important. Candidates expect to outline the two methods you will recall under section 211. Only a few candidates make reference to relevant rules. They also expect to discuss the rules governing variation of class rights. Most pointed out that a special resolution is needed. So I think partially they did quite well. It's just a few items they missed out. Okay, so whether the directors can reduce the company's capital by canceling shares. So we have covered this before already. So this is about the doctrine of capital maintenance. So if you're outsider dealing with the company, you would expect that the money invested in the company would remain in the company so that if required can be used to repay you if you extended credit to the company. Then you will recall we have Section 210, which say you are allowed to reduce the share capital as long as you do it using one of the methods in Section 211. But these are the restrictions. You cannot do so if it ends up with no members or if there's an article that prohibits or restricts the reduction. And then these are the two methods, either special resolution by solvency statement or special resolution confirmed by the court. If you use the first method, you recall solvency statement is where the directors form the opinion the company can pass the solvency test. And then the solvency test is that the company can pay its debts and it can also pay its debts in the upcoming 12 months. So it's forward looking. So application. So you need to have the doctrine of capital maintenance basically to protect the creditors. So that's why you have to be careful when you do a share reduction situation. If you decide to do under the procedure 211, you need to check whether the articles have any restriction. Based on information, there's no such restriction, so we can assume there's no such clause. Using the special resolution and solvency statement route, then you need to see whether the company can pass the solvency test. So in our story is that the company continues not to be in good financial standing, is in financial trouble. So that's why it is possible and cannot repay the debts as they fell due. So in that case, may not be successful because would not be able to use the first method to reduce the capital. And I think also more difficult if it tries to get the approval from the courts. So what about, in the story it say if we cannot cancel the shares, can we reduce the percentage? Would that be a variation of class right? If so, we've seen this before. Section 180 is basically you need the consent of the holders of the shares in that class. And then also, if it was successful in reducing the percentage and if you disagree, you can go to court for help. And we've seen these before, how we distinguish between just affecting the rights and affecting the enjoyment of the rights. If it was just a reduction in capital, that would not be an alteration of rights. We've covered that before. So in application, you can see here, we need to see they are reducing the percentage rate. So clearly that will be a variation of the right of the preference shareholders. So in this case, it's not talking about reducing all the share capital. It's actually talking about changing the percentage rate. So it clearly is a variation of rights of that shareholders in that class of shares. So in that case, you will need 75% consent in writing, or you need to pass a special resolution in a separate class meeting of the preference shareholders. So in this case, May, she holds 25% of the preference shares. So she would not have enough shares to block the proposal to vary the rights of the preference shares. So most likely, if no one else disagree, then that variation will receive the required consents and then can pass the resolution to alter the articles. But since she held more than 10%, because she holds 20%, held 25%, I should say, she can, she's eligible. She can apply to the court under Section 182, but then the court will see if the change would unfairly prejudice the member. So if 75% of preference shareholders already agree to a variation, it will be difficult to convince the court that the change is unfairly prejudicial to the preference shareholders. So it's in this case, unless there are new information, does not look like she will have a strong case. Okay, so we have the next question, question number 7. So here we have Crow's Nest Limited, a furniture retail company, has 2 directors, Ravi and Sam, who are also the only shareholders of the company, each of them holding 50%. So the company is unable to pay its debts, and on 31st of March is placed in compulsory liquidation. The available assets are stock in warehouse 900,000, 3 vehicles 300,000, and the balance of 100,000 left in the bank account. So it's about 1.3 million approximately. So again, by this time you would already see we have a insolvent liquidation situation. We have limited assets, and I would expect they will tell us about the different liabilities and see if they have any charges. So liquidator has discovered that the company has outstanding tax bill of 200,000. There's a secured loan given to Sparrow Bank. It is outstanding. The charge even state that it is a fixed charge, but the bank allow Crow's Nest to continue to deal with bank's account. So this is almost identical to the story we saw before. And then there are also suppliers have submitted claims, outstanding debts of 600,000 to Magpie Limited. Company owes 300,000 in rents, and there's also a debt of 100,000 for cleaning services. So all of the debts are unsecured. There are 15 employees coming forward for unpaid wages, and each of the employees claiming 20,000. Liquidator's fees is 120,000, additional expense 60,000. So explain the priority of each claim. So you can see we've covered this before, and it turns out each year when they have this question, the candidates do well, which is wonderful. That's the order of distribution. We've seen that before. So the fixed charge, we've covered these cases before. I think it's just looking in substance, whether it's a fixed charge or a floating charge, and just having a label, writing or calling it fixed charge in a document would not be sufficient. And then applying to this case, it would look like it is just a label. It will look like the charge has more of a characteristics of a floating charge, and therefore would have a lower priority than a fixed charge. It will come after preferential creditors. So there's a floating charge granted to Sparrow Bank. We need to know validity. So we've seen this before, Section 267. If a floating charge created during a relevant time is invalid, unless you fall into the exception of the new money exception. And then in this case, because it is a connected party, then the relevant time period is 2 years. Okay, so this is slightly different to our previous question, where it's a non-connected party. So commencement of winding up is the date of petition, which is likely to be between January and March 2023. As the date of agreement is the 10th September, it is more than 2 years beyond this date. So therefore, the floating charge was not created during the relevant time period, and therefore it should be valid. It will fall behind preferential creditors in priority on liquidation. Liquidation expense, we've covered this before, and you can see the liquidators fees and additional expense should be able to claim. And preferential creditors, we also covered this before, so that's why you can see they are preferential debts if it is the wages of the employees up to 8,000 per employee, and then statutory debts within the 12 months, it will be unpaid tax or rates that will be treated as preferential creditors as well. And then you can see the amount of unsecured creditors is the three of them. So if $500,000 is remaining for these parties to be repaid, then unsecured creditors will be repaid pari passu. That is in proportion to the size of their debt. And using this amount, you can see SWIFT will be paid a bit less because it's only owed 100,000, around 10%, whereas Magpie will be paid more because it's owed 600,000, around 60% of the unsecured debt. Okay, so we have quickly finished question 7. We can now move on to question number 8. With Pixelet Limited is a company offering management consultancy services. Its directors are Kingsley and Benson. The articles is basically add-on from the model articles, contains the following additional objects clause. The company may engage in any activity directly related or incidental to the carrying out of management consultancy services. So Pixelet has, so you can recall objects of a company now is no longer compulsory. So it's entirely up to the company to decide whether to write them down. If they do put down their objects, then they need to follow, obviously. So this seems to be one of those situations. So Pixelet recently signed a contract to provide management consulting service to a new client, Color Wash Limited, an online clothing retailer. The directors know that Color Wash has a reputation for low pay and poor treatment of workers. They've also seen evidence that its production methods are not environmentally friendly. Furthermore, Color Wash has recently been the subject of some negative press coverage relating to its tax affairs. Benson is unhappy with the deal, which he believes will damage Pixelet's reputation, but Kingsley insists that Color Wash pays well and that the deal offers opportunity to make significant profit. So different views on doing the business. Directors of Pixelet would like to expand Pixelet's business to run a management training center in Central, have therefore signed a lease with Hong Kong Property Limited in order to run some training courses. Some of Pixelet's shareholders are unhappy with the expansion plan, would like to challenge the validity of the lease, and the shareholders have also just discovered that Kingsley is one of the shareholders of HKP. So it's basically whether the company should enter into this business or not. So the question is, discuss whether the directors of Pixelet are in breach of their director's duties. You can see this is quite helpful. This is specifically asking the candidates to discuss director's duties. So if you see this, then I think it should be quite clear. And then it's the lease between Hong Kong Property Limited and Pixelet valid. Explain your answer. Okay, so you can see director's duties and authority to enter a contract to bind a company. They are from Learning Outcomes 2 and 3. In the comments from the examiners, it said many candidates simply listed and described all the general duties of directors without any analysis of specific scenario. So this is something I've seen sometimes as well in some candidates. When it comes to directors' duties, they just list out every one of them. Okay, so please don't do that. As you know, there are quite a number of different directors' duties. So definitely look at the story and then discuss the ones you believe are relevant to the story at hand. Okay, otherwise you will end up spending a lot of your valuable and limited time writing on matters that is not relevant to the story or the question, and most likely will not score any marks. Okay, so you want a return on your investment. You're investing your limited time and your limited energy to write your answer. You want and you hope and you want what you have written will score you marks. The more the better. Okay, that way you will increase your chance of passing. So definitely, I would not recommend any student just write down every single thing and hoping some of it will be correct. But if you use that approach, then you run the risk that you spend a lot of time and effort writing pages and pages of answers that's not relevant to the questions, and in most cases will not score any marks. So you get zero return for your investment. So invest your valuable and limited time wisely. That's my suggestion. Okay, in part B, candidates were expected to explain the rules regarding ultra-vires transaction. Only a few managed to explain the relevant rules and sections. Many explain statutory derivative action. So you can see we looked at statutory derivative action in an earlier question. And in our story, you can see it's nothing about that. So if you wrote that type of answer, of course, it'll be hard to score any marks at all. So clearly, this is about the company having an object and asking what happens if a company decides to act beyond its objects. Okay, so whether the directors have breached their duty. So I think Smith and Fawcett will be one. So its directors should act bona fide in the interest of the company. And then in Akai, it said acting contrary to the company's constitution may also amount to a breach of duty to act in the interest of the company. So the first case is telling you that is the fiduciary duty, that is the director's duty. The second case is telling you of an example of when it may be a breach of that duty. So in that case, the example was doing something against your company's articles. If your company's constitution, your article says you can do this, you cannot do that, and you act against that article, then of course, it will look like you have breached your duty to act in the interest of the company. And then in the third case, of course, we have seen this a number of times already, is a director has a duty to avoid a conflict of interest. So if you have an interest in a particular transaction, you must disclose, otherwise you will have a conflict of interest. And then you will recall, we've seen this section a number of times already. So under section 536, if you're a director, you're interested in a transaction with the company that is significant and the director's interest is material, then you must declare the nature and extent of your interest to the other directors. Okay, so we've seen this one before. So application. So Color Wash has a bad reputation for poor treatment of workers, not being environmentally friendly, and negative press in relation to its tax affairs. So it is claimed that taking on Color Wash as a new client may damage the company's reputation. However, as in Smith and Fawcett, you need to prove that the directors intended to act against the interests of the company. So if the contract can bring significant profits to the company, it may be difficult to argue that there was a breach of its duty. So there's one thing about some claims by other people, but at the end of the day, as a director, you must act in the interest of your company. So if a contract works well for your company and can earn significant profits, generally speaking, it will be difficult to say you're doing something against the interests of your company. So for the expansion of business to run a management training center, it may be argued that the directors had exceeded the company's objects clause and had therefore acted contrary to the articles. So you can see the objects clause say, this is what we can do. And here the directors expanded their business to do beyond what is permitted in the objects clause. So although in the archives case, it was accepted by Justice Stone that this may amount to a breach of duty to act in the interest of the company, still need to show that the directors were acting against the interest of the company. So it's possible, but then you need to show how would that go against the interest of the company in order to succeed in the argument that is a breach of duty. So you can see for this question, first of all, you explain the relevant director's duty. Number two, you apply those requirements to the facts, to the story. Some may need a bit more discussion, and then that would already be finished. In other words, it may not be possible for you to arrive at a final conclusive answer, but your discussion, your relevant discussion by discussing the relevant director's duties, by discussing the relevant sections or ordinance applied to the facts of the case, already score many marks already. So For the lease agreement with Hong Kong Properties Limited, Kingsley should have disclosed his interest before the company entered into a lease agreement. So remember, we look at the session. You need to make the declaration, disclose your interest as soon as practicable, but you should also do it before the company concludes the transaction, sign and be bound by that contract. So as in the Aberdeen case, there's a conflict of interest. It is unknown whether Kingsley will be acting in the interest of the company or of HKP when negotiating the lease agreement. So that's why the director, in this case Kingsley, he may be wearing two hats. Was he acting as director, negotiating lease agreement in the interest of this company, or was he doing the negotiation for the benefit of the other company? So if it is for the benefit of the other company, the rents payable may be higher than necessary and vice versa. So that's why there's a conflict of interest. So that's why Kingsley should have declared the nature and extent of the interest in HKP to the other directors, and they can decide what to do. They can decide, okay, Kingsley, you should not be in charge of negotiation. Or they can decide, no problem, we'll go ahead. Or they can decide, no, we won't lease from this company. So at least they have the right to know and they can make a decision. So if no declaration was made, as you recall, the fine is at level 6, which is 100,000. Okay, so whether the lease agreement is valid. So despite all those breaches, the company still signed a lease agreement with another company. So you want to know whether it is still valid, meaning can that company still demand that you pay rent to them as stated in the lease agreement. So our starting point will be section 116. If the objects of the company are stated in its articles, the company must not do any act that it is not authorized to do so by its articles. So companies nowadays, it is no longer mandatory to have objects. Objects basically say what your company will do or can do or cannot do. So it's not compulsory, but of course, if you wrote it down in your articles, then your company should follow. So a member of a company may bring proceedings to restrain the company from doing that act. So if the company was contemplating or in negotiation, then a member can go to court, asking the court to make an order or an injunction to stop the company from continuing from doing something that is not permitted by the objects. However, an act by a company is not invalid only because the company acted in contravention of these subsections. So this is talking about the outsider, the other party, the company that is leasing the property. What you do internally, even if it's wrong, the members can make a claim against the directors. It should not affect the outside party. So that's the reason why they have subsection 5. So expanding the business, in this case, is outside the scope of the objects. So that's why it is a breach. And that's why the members can actually go to the court to complain. But since they have already entered into a lease agreement based on subsection 5, it would not invalidate the agreement. So it is to protect the third party. In this case, it will be Hong Kong Properties. Okay, let's now look at question number 9 of the June 2023 paper. So here we have two friends, Marco and Louis. In 2018, they set up an advertising agency in partnership. Over time, the business grew to become very profitable. Following advice from the lawyers, they decided to incorporate it as a company. So you can see here, very similar to a quasi-partnership situation, but let's keep reading and see what's going on. So a certificate for incorporation was issued on the 10th of November. The company adopted the model articles with the additional clause. Number 1, a director may be removed from office at any time if 2 or more directors so require. And on any resolution to remove a director, the director whose removal is sought will be entitled to 5 votes per share. So this is quite interesting because the article or the clause is talking about under how you can remove a director. And here you can see requirement is 2 or more directors. And secondly, is saying that if you are voting to decide whether to remove the directors to be removed will get 5 votes per share. So it's quite interesting. It has more voting power. Is it to prevent the removal? So at that point, Marco and Lewis were the only directors. The company had 1,000 shares. Marco and Lewis each has 500 shares. So now, in January 2022, Marco's sister, Maria, decided to invest in the company. Marco and Lewis both transferred 100 shares to Maria. Unfortunately, it quickly became clear that Lewis disagreed with Marco and Maria about the future direction of the company, and there was a heated argument in December 2022. Marco and Maria called a general meeting and with an ordinary resolution removed Lewis as a director. So Marco and Maria stated that as they have collectively hold the majority of shares, resolution is passed. So Lewis is angry and upset. He tells you the meeting took him by surprise. It was called with only a day's notice and no agenda was circulated beforehand. So you can already guess, hopefully, this is talking about a removal of director, whether they have followed all of the requirements, and also whether those clauses in the articles can be are valid and can be used. So let's look at the question. Advise Lewis of any reason why his removal as a director may be invalid or unlawful, and whether any other personal remedies under the company's ordinance are available to him. So removal of directors and the remedies are under learning outcomes 2 and 3. So let's look at the examiner's comments. You can see very good. Most of them able to explain the relevant process for removing a director, correctly point out about the ordinary resolution and special notice requirement and the rights of directors. So we've gone through this in the past, so I think you're very clear on the points made by the examiner. But in part B, only a handful of candidates could make reference to relevant issues and rules. Many candidates explained the concept of a statutory derivative action, which was irrelevant to this question. So hopefully, after the previous questions, you can understand the comments from the examiner. Okay, the difference between a derivative action and a personal action. So you will recall I explained earlier is if you want to make a claim on behalf of the company, and therefore the remedies are for the benefit of the company, derivative action is the way to go. But if you want something to help you yourself, an order, a relief, a share buyout order, then you will not use statutory derivative action. Okay, so that's what the examiner was trying to explain here, is if someone discuss about that, why it is not relevant to the question for that particular year. Okay. Okay, so first issue to discuss is the removal of Lewis as director. We have already seen this before, section 462. You can remove by ordinary resolution as a general meeting, but you must have the special notice. And of course, you can see here is about the voting. So we've covered these sections before, but we haven't seen these sections before because it wasn't relevant before, okay? Now it's talking about how many votes you can have per share. So under subsection 7, for a resolution to remove a director, no share may carry a greater number of votes than it would carry in relation to a generality of matters to be voted on at a general meeting. What it is saying is normally in a general meeting, if it is 1 vote per share, then when you're voting to decide to remove a director, then no share can have more than 1 vote. Okay, so I think you can already understand why this subsection is relevant this time, and I think you can already understand how this would apply to our story. Okay, so if shares carry special voting rights to some matters but not others, to the generality of matters to be voted on is to be construed as reference to matters which shall carry no special voting rights. So what it's saying is basically it would not apply to this situation. Okay, the special notice requirement you can see here is basically must be given if you want to have a meeting and you have to have a notice, you have to do it how many days in advance. And because in our story, you'll recall is he was not even informed properly about the meeting, and it was very short notice. So that's the reason why this section and subsections is stated here. And of course, you can see the director. We have seen this one before. Directors is first of all should be notified about the calling of a meeting to remove the director. Therefore, must send a copy of the notice to the director. The director is entitled to be heard at the meeting. Also have a right to make written representation if he does it in time and is circulated to the members. And then the requirement here is the company receive, this is about if it is received too late from the director, then of course, then you can subsequently send a copy to the member later on, or you can have it read out at the meeting. So it's not exactly the same way, but you can achieve the same outcome. Okay, so director's right to protest against removal. So on application by the company or anyone who claims to be aggrieved, so I guess it's the directors to be removed, the court may order that the company is exempt from complying with the request if it is satisfied the person who has made a representation, made a requirement under the subsection has abused the right to do so or used such right to secure needless publicity for a defamatory matter. So what is this talking about? This is talking about the director's rights to make written representation and have it circulated to the members. So if the company can show that the directors will abuse this right and use it to get needless publicity and for defamatory matter, meaning make bad remarks about other people which cannot be supported, then the court may agree on application to say, then the company no need to do this part. Okay, so you go straight to the meeting, have the director heard during the meeting, and then you guys can vote on whether to remove the director or not. Okay, so application. So here, to remove Louis, you only need an ordinary resolution in a general meeting. Since Marco and Maria together, they held 60% of the shares, they should have enough votes to pass the ordinary resolution. Now, there's an additional clause which says that the director to be removed can have five votes per share. But as we saw in those sections just then, Louis will only have 1 vote per share, despite that clause in the articles. So that's the reason why Marco and Maria will have enough votes to remove Louis. And for the special notice, should be given within 28 days. Since Louis was given only 1 day's notice, it's likely subsection 4 was not complied with. Also likely that the copy of the proposed resolution to remove Louis has not been sent to Louis, and likely Louis was not given a chance to be heard at the meeting or make a written representation. So all these Louis can complain to the court for not following the requirements in the ordinance. Okay, so personal remedies available to Louis. So clearly he can see all these things done not properly done. What can he do? So we're now not talking about a derivative action. It's not making any claim on behalf of the company. It's seeking personal remedy, something for Louis himself. Maybe to help him, maybe to compensate him, we'll see. So that's the reason why it will be section 724. We saw this before in our previous slides. If the company's affairs generally was conducted in an unfairly prejudicial manner to the interests of the members or to a member, or a particular action, a particular transaction, where the acts or the omission of that act turns out to be prejudicial. In that case, the court can make order that it thinks fit, which includes, for example, regulating the conduct of the company's affairs in the future, or more likely the buyout order, asking other members to buy the shares or asking the company to buy the shares. So here are some court case. Exclusion from management may amount to unfair prejudice, so this may be one of the claim. Also, to determine the interest of a member, the court may have regard to wider equitable considerations. So for the owners of a business who sold shares in a company in return for a promise of injection of funds, which did not occur, could stay on as directors, forced to resign, was held that the dismissal and exclusive management might be unfairly prejudicial to the interest as a member. So this is just an example where it would amount to unfair prejudice. Court found that there was unfair prejudice and ordered the defendant to buy out the petitioning shareholder at a price fixed by the court. So you can see sometimes if you really cannot agree, relationship is bad, the best thing to do is just give the money back to the shareholder. And the shareholder can take the money and go somewhere else. That's usually one of the best commercial solutions. So application. In this case, Marco and Louis founded and managed the business together. So by removing Louis as a director and excluding him from management of business, which he helped founded, based on the case, it may be possible to argue it was unfairly prejudicial against his interest as a member. It was also confirmed in this case when Marco and Maria excluded Louis from management of the business, can argue it was unfair prejudice and petition the court under 7241. If the court agrees, it may exercise its powers under 7251, makes any order they think for giving relief. So you can see this number of different grounds, but it's still about very similar matters that Louis can raise to the court. And then based on Grace and Biagio, we saw this case before, can basically the court issue a buyout order requiring Marco and Maria to purchase Louis shares at fair value. So that may be a good way to resolve the situation. Okay, so we have now finished the past exam paper for June 2023. So if you want, you can take a break now before we continue with the next exam paper.